Good morning, everyone. Happy Sankranti, Happy Bihu, Happy Lori, and Happy Pongal to everyone. Thanks, everyone, for joining this program in a good number. Today is this topic of minutes is actually very near and dear to all the CS in or in job. And I'll say as the experience passes, each CS feel the importance of minutes every day and every year. It's near and dear to my heart because I feel drafting minutes is an art. It's require not only your knowledge, that is foremost, but it also involves the squeezing of all your knowledge, experience, smartness, intelligence, and all your experience. Generally, it is observed that freshers or our trainees take minutes as very neglected area. But friends, this document shows the level of knowledge, experience of draftsman. Because everything happened, no one can see. Of course, now it is a video recording is there, but please note that we have to maintain the record only for 1 year. What is permanent is this record only, which will speak after years and years that what happened in the history and will decide the future course of action, justice, rights, duties, liabilities of each and every stakeholder involved in that minutes. So my dear friends, this is the most important document to be drafted by a company secretary. And one has to be very, very careful in this. One will understand the importance of minutes when the company or that minutes is under scrutiny, under due diligence. Any outsiders will read, at that time you will understand the importance of minutes. For example, I'll give you in my early age of practice, we had a private limited company and we have done prepare the minutes, and suddenly one day High Court called, there was a dispute, the minutes, and we never got a time to check what we have done because the client immediately submitted. It was to be deposited in 1 hour in High Court. Next day, it was to be decided on the based on my resolution drafting whether the matter will be in the favor of my client or in others. The matter was the director has taken action, and the appointment of director itself was challenged by opposite party, and that's why the minutes was asked. And my dear friend, judge was reading the minutes word by word, and that was the point where my legs was shaking, because you can carry so much onus on you. And that time the resolution was taking, and that the one of the director of the any one of the director of board is authorized to sign and file the necessary forms. Judge said, since the signing authority is given, this director is authorized to sign, this form is valid, this appointment is valid, all action done by him valid, and the decision in favor of client. At that juncture, in the age of 26, I realized the importance of minutes myself. And that's why I'm telling from my experience, boss, it's very important document. So please give importance. And I'm now insolvency professional also. In that, my minutes writing, this experience helped me to a great extent, because there also nothing left, only minutes. That is the only proof which protect the insolvency professional. So word to word and opposite there, your minutes, there will be a counsel who will be charging per appearance 2 lakhs. I have faced this. And the minutes is challenged, and then the judge is reading one by one, and that counsel cannot argue. Minutes was perfect. And I said, hats off to my, my experience that helped me. So friends, such an important topic, and we have very experienced people. Of course, our always evergreen, our Mr. Bala. Mr. Bala had a birthday yesterday, so belated happy birthday to Mr. Bala.
Oh, happy
And
birthday.
also
Thanks a lot. Thank you so
our
much.
good friend, Mr. Sanjay Dolakia, a very experienced practicing CS, and Mr. Sunil Lalai, also a very senior CS. I would like to introduce and welcome our both the guests today, experts. Uh, Mr. Sanjay Dolakia is carrying on the profession of company secretary in practice since 1991. He is a BCom and LLB, and he is representing his clients in company law, SEBI compliance, and various other listed companies. He is also secretarial auditor to various companies. He also handles LLP and presents handle merger, acquisition, and appear before NCLT, ROC, RD. Welcome, Mr. Sanjay.
Thank you.
We have Mr. Sunil Lalai, who is currently working with Endurance Technologies Limited as a company secretary and executive vice president legal since 2011. Prior to that, he was company secretary at Thermex Limited for over 14 years. He is a commerce graduate from Bombay University and member of ICSI since 1991. He was previous to Thermex, he was working with Rallis India High-Tech Containers. During his career span of over 3 decades in public listed corporates, he has varied experience in different areas apart from regulatory compliance and matter under Companies Act, SEBI, FEMA, and other corporate law. Welcome to you both. We will be very proud to have you on this board. And of course, our Sailesh Bhai, I specially called him today. He should be here. Friends, he is my SSB colleagues. And whenever we finalize secretarial standard, entire board will give the final touch up to Sailesh Bhai. Because his comma, full stop, you see this current secretarial standard, the final touch up is by Sailesh Bhai. So he will speak like a law only and all drafting. Welcome Sailesh Bhai, welcome all. I'll now hand over to our own Bala, Mr. Bala, to introduce the topic, and then both the speakers, both the invitees, Sanjay Bhai and Mr. Sunil, for their topic talk on 2 to 5 minutes. Thank you.
Good morning to you all.
Mr. Bala, you are on mute.
Good morning to you all.
Good morning.
I'm very happy to welcome you all on my own behalf and also on behalf of Mehta Mehta for this webinar. As Tipti has elaborately said how important is the minutes is, we all will recall, and there is a subject in our CS course on drafting, because that is the reason why the drafting subject is actually included to emphasize the importance of the minutes and minutes writing. Because everything in the company emanates from the minutes, because shareholder, they do not get involved in the day-to-day affair. The authority is delegated to the board of directors. They have given the power, but they have given only a restricted power. Any power more and over and above they want it, they have to go to the shareholder, get the more power through the general meeting authorized by the shareholders. So that means that directors are expected to act within the articles, within the given power by the shareholders of the company. So whatever the directors are taking a decisions, the company secretary, who's the part of the meeting, has to be very, very carefully go agenda by agenda item, understand what is happening in the meeting, especially the decisions which are taken by the board of directors, which convert into the action in the business activities, is very, very important. That is where the question and disputes and litigation which actually arises. What decision has been taken, what authority has been given, what action actually follows. That is the gist of the things. So that way the company secretary has got a very, very important things to watch the meeting closely, take the necessary notes. If he has got any doubt, he has to actually seek clarification from the chairman of the company, because who will actually tell you what is the decision is taken, because ultimately chairman will conduct the meetings. And the meetings is required to be drafted very, very carefully, precisely, focusedly, what exactly the decision is taken. Not only that, as Dipti puts it, suppose somebody refers the company about 20 years later, what has happened on that particular day, how the decision has arrived. The preamble of the minutes should also state what is the subject matter, what is being considered, what are the things are all deliberated by the board of directors, how the decision process is taken. That is one. Second thing is there are a lot of liabilities actually on the directors. In certain matters, if the directors do not agree, there can be a dispute, there can be a disagreement, etc. It is not necessary everybody will agree. So if there are certain things, there are certain concerns, in such a cases, if those concerns are raised or somebody is actually not approving, somebody is desisting, then that also needs to go in the record to safeguard the interest of the director, which is very, very important here. And again, the minutes acts as the evidence in the court of law. Tripti has actually put it number one. Number two, it is not only the minutes goes only the company law, it is referred by all the authorities. Because we have come across in my lifetime, even the income tax department wanted to verify the minutes and go through the things and collect the details when it's coming to the financial decision making process, etc. and other things and all, we have to produce the minutes. That is the thing. And other thing, we also know the minutes is the permanent document of the company. Right from the time the company is incorporated, even after the company get married, that means amalgamated, the minutes is actually passed on to the next company. It will be kept preservedly there. Because till such time the company is finally struck off, the minutes are going to be there in that company. That is very, very clear. So therefore, the minutes is very, very important. Decisions are to be recorded. Action follows on that. Not only that, follow-up actions also referred from the minutes. Because we all know when we are conducting the meeting, there is always one item, action arising from the previous meeting. So what is decided, what is the action, who is supposed to take, whose accountability, what other thing has been taken, that also arises from the minutes. In the light of that, the drafting of the minutes is very, very important. And not only that, following from the minutes, the various other reports are generated at the end. That means financial statements. When you are preparing it, the annexure to the financial statement, it is a board report. In the board report, you know that we will have to give how many meetings were conducted, who are all present, who are all absent, what is the detail, all those things we'll have to give. Everything is actually driven only from the minutes. So minutes actually a permanent record which gives the factual thing what transactions in the company. From that point of view, it is a great skill of art writing the minutes. So it occurs very, very important. So company secretary need to be very, very careful, especially my advice to the youngsters. They need to master the act of writing the minutes. They have to actually skillfully learn how better minutes can be drafted. That is what I would say. I hand over the mic to Mr. Sanjay Dolakia to add his views from his experience.
Thank you, Mr. Bala. Good morning, everybody.
Good morning.
Thanks, Dipti, for inviting me as an expert on this. There are a lot of senior guys around, so I will just contribute some of my thoughts or some of my experience which I had. First of all, the young people are facing sometimes a very difficulty because I am practicing from day one, say 91. So I found the era of writing minutes by hand to the electronic writing of minutes. Also, the migration from physical to electronic, we have witnessed a lot of changes in drafting, especially to the complexity of the corporate world. The youngsters who are drafting, see, we used to write down the minutes by hand. And that was a big challenge for us because we have, there was no duplication allowed. So before writing, we used to have the thought process, how to draft minutes. As Dipti correctly said, that it is our evidence in a court of law, and the counsels who are cross-examining will ask how this was drafted and how this has taken place. So from that era to the current era of electronic era, and also drafting skills has to be improved by the company secretaries. I also come across papers or the programs which are readily available in the present scenario to various, there are various companies who sell the minutes draft programs. So those are definitely our boon, but ultimate skill lies with the company secretary who takes care and who writes the minutes, or who actually goes into the depth and understand it, how that has happened. There are also a lot of issues while drafting the minutes. Electronically nowadays, most of the meetings are conducted by audio video mediums, and there are chances that some of the recordings which we see is not captured properly in the minutes. Some of the decisions taken by the board of directors are not correctly put it in the minutes. So it is the prime responsibility of the company secretary to see that the correct intention and the correct decision taken by the board of directors is reflected in the minutes and is circulated after consulting the chairman. Coming to the other aspects of minutes, which are also highlighted, Mr. Bala, he's rightly said that company secretary's role is very, very crucial in drafting of minutes. We have to see also the secretarial standards which are applicable while drafting the minutes, and all and understand the real scene or real picture that can be presented to the outside world. There are issues regarding the practical difficulties faced by most of the company secretaries, that after the meeting is over, the agenda item is not discussed and some of the resolutions are kept in. So at that particular point of time, the company secretary has to be very firm and explore the possibilities of passing those resolutions, which are of prime importance, even though to the business community at large, that you should and explore the possibilities of passing those resolutions by circulation, or how we can conduct those, how we can incorporate those resolutions which were not at all discussed by the board of directors. So this is very important, and I personally feel company secretary's role in drafting of minutes is to the best of the best, and also they should take care because there will be permanent records for all authorities, as rightly said, under income tax or other companies act. I also advise youngsters to make a habit of writing by hand instead of writing in the computers. You will be surprised when I used to appear for an interview. The senior company secretaries used to give us the newspaper and say, write down one para from the daily like Economic Times or this thing. And when they used to copy those, we used to commit a lot of mistakes. So even while copying the text from the available printed copy, we used to commit mistakes. So this is a minutes. You can't take chance. So I request now the other learned speaker to carry forward on from here. Thank you.
Thank you. Thank you so much.
Mr. Sule, you can take it.
Yeah. Thank you, Sanjay. So thank you, Dipti, for the warm welcome. And thank you, Professor Bala. Thank you, Mr. Sanjay Dolakia. I think the overall context has been well laid out, signifying the importance of what the minutes implies from the statutory regulatory authorities, or from producing it as an evidence, or even for the matter as referring for the past transactions that have happened, or for that matter, when due diligence is happening for an organization, how significant it is. Only when the minutes go into scrutiny would we come to realize the importance of it. So not only from the regulatory part of it, but also from the drafting skills point of view, it's very important, as my learned earlier two speakers have emphasized upon, as to why it's so really significant and important to nurture the skill of drafting. There is nothing right or wrong about it. It's one's own individual style and skill of writing. But what is of importance and essence is that whatever that's recorded is recorded appropriately, not missing out on the essence, and also what are the actions that are emanating out of the decisions that have been taken, because other stakeholders within the organization or outside, they would be not having privy to the entire recording of the minutes, even though in today's world, we are experiencing video recording, but still the video recording, although it's available for a short span of time, the recording per se is not privy to everybody. So what is culled out from the minutes or from the meeting and translated into minutes is something your own skills. my professional colleagues on this particular webinar, people those who are working with public listed companies, I'm sure that you all would have had interactions with independent directors. Now, independent directors are very touchy about on various aspects of how the minutes are recorded. The grammar, the full stop, the comma, everything. At times, a simple mistake over there changes or alters the essence of what is being said over there. So, one more practical side of it is like, everybody would have had an opportunity to go through either a taxman or Ramaiya. As when we are in an organization for years, an indexing of minutes, this is from a practical side of it. So from the minutes point of view, recording of the minutes, after every meeting, it's better to maintain an index of minutes, a subject-wise index, the way we have it behind Ramaiya or a taxman. It gives a very easy and quick reference to what the minutes, or maybe it could be 3 years, 5 years prior. It becomes very handy, and it's like a Kaizen, which generally it helps pull out the right reference. And when we are superseding a particular resolution of the past, it becomes really very handy. So that's on the practical side of it. Most of the points have been covered by Professor Bala and Mr. Dholakia. So I don't think that I have anything else to add to that.
Okay, then thank you.
One thing I want to add here. I happen to work in the Democratic Republic of Congo and the Equatorial Guinea. Sanjay Dholakia was actually mentioning, whenever we are writing the minutes, etc., there are certain things when the minutes are kept open to inclusion, which is not discussed, etc. In those countries, I have actually come across what is the procedure in those countries are there. We have a ROC, they have something called a company register. The rule is there, every board meeting minutes are required to be filed with the company registry. Okay, immediately after 20 days. My God. Now the question is, when I went there, I was really surprised. I checked with the people. How can we actually file these things as being a public document? It is open for inspection. Then I have been told, no, that is not required. You can discuss anything, everything in the meeting. But what is required to be filed is only those decision taken minutes are to be filed. So in the light of that, I am supposed to actually prepare 2 minutes. 1 minute only on the matters on which decisions are taken, and other minutes, the regular minutes, which everything is discussed. So the minutes which are decision taken, which are required to be filed within 20 days to the registry. So rest of the things we keep for our own record. In such a case, beyond 20 days later, we cannot do any alteration, anything, addition, deletion, etc. Nothing can be done because it is already filed. But anyway, that sort of a restrictions is not there here. So in the most of the private companies and unlisted public companies, etc., the minutes are kept open. If directors agree and other thing and all, yes, practically it is happening. But that is not the good governance practice. If it is not discussed, it should not be. That's what I will put it actually, because I never followed that practice. But anyway, that I cannot comment much on that. I will restrict my comments to that extent. I just thought of sharing in the other 2 countries what is the experience I had.
Thank you.
Very good dimension you have given. Very good knowledge because of your presence. Thank you, Mr. Bala, for such interesting information.
But Bala, filing all decisions with the ROC in those countries would also require you to file confidential decisions. If you are going to make a bid or not going to make a bid, if that decision is taken, you will have to indicate that it was decided to take a decision to bid.
That is right. But the only thing is we'll have to give a rider to them, because of this particular regulation, this should not be made available to the public, etc. So it will be kept disabled for a particular period till the bid is over.
Okay. So it will not be generally available for inspection. This will not be available for inspection.
Correct.
Okay.
That is always there.
Okay, friends, I think now we can start. But before that, I will like to announce and I'll introduce our new partner, Mr. Jagdish Bhai Patel. And he has joined us. Their practice is merged with Mehta and Mehta. And today is attending our first webinar, Mr. Jagdish Bhai Patel. Welcome, Jagdish Bhai, to Mehta and Mehta. And Mehta and Mehta has now office in Vapi and in Borivali also. So we welcome Jagdish Bhai here.
Great.
Thank you, madam.
Congratulations.
Yeah, Jagdish Bhai, you remember. I hope you're well.
Yes, Sanjay.
So we will have, he's such a senior and we will get Mehta. Mehta is fortunate to have his experience and knowledge. Okay, we can start now PPT presentation. Mr. Siddharth, you can start. Mr. Siddharth is our article. It's Mehta and Mehta practice that all presentation will be prepared by only our trainees so that they get trained to prepare the PPT present before the public. It's a part of that training. So Mr. Siddharth has prepared a very good PPT, and Siddharth, you can start the presentation, please. Thank you.
Thank you, ma'am. Thank you. A very good morning to all the panelists and all the experts who are attending this presentation. My name is Siddharth, and today's topic for the presentation is minutes drafting and its importance. So without wasting any time, we shall start the presentation.
Siddharth, you are on mute.
What do you mean by minutes? A basic question which can come in everybody's mind. So in a layman language, we can consider that the minutes is the recording of the meeting. So basically recording of the meeting, which is under the physical form. So minutes is not been defined under the Companies Act as of now, but it includes in the books and paper under section 2, subsection 12. And also our secretarial standard 1 has said the minutes means a formal written record in a physical or electronic form of the proceeding of a meeting. So just it means that anything which has been discussed under the meeting, it has been included under the minutes in written form or in an electronic form. Why minutes are important and why drafting of the minutes is important. There are some of the points which I want to like to discuss on this. Drafting of the minutes offers a legal protection. Whenever a company has came across any of the legal action, minutes can always give a legal view or a legal evidence and can act as an evidence in that case. They provide a structure to the company to derive an action. Basically, the minutes always contain the resolution which has been approved by the board, and it contains the action or the decision which has been taken by the board on a particular matter. Minutes give reference to the various stakeholders about the decision. As we know that the shareholders can inspect the minutes of the meeting, so they can know about what the decision has been taken by the board in the meeting. Minutes are the final authentication of the transaction. It means that any of the transaction which has been authenticated by the board or the members, minutes provides a recording of that. Minute helps in knowing the approval which is given by the director for the specific and also act as a proof. So whenever a director who given assent to a particular transaction, so it's been recorded in the minutes that such director has given its approval for that particular transaction, and it also records the dissent of a director when he doesn't give an assent to the particular resolution.
And this is very important, as you know that many decided cases, independent director, their role and their responsibility, if they give dissent, as you know, one of the decided case, independent director shown is in dissent, and they were discharged of duties. Sorry.
Siddharth, if a director dissents,
Yes, sir.
Is it necessary to mention it if he does not require that it be mentioned?
Basically, the Companies Act does not provide any of the provision on that, but it has been mentioned under the SS that any of the assent or the dissent of the director, it should be mentioned in that. And if any of the dissent is to be there is been given by a particular director, it should mention below the resolution that the particular director has given a dissent and his reason for such dissent. So we
whether the director insists on this mentioning or not, is it? It should be mentioned.
Yes, sir. It should be mentioned under the S.
Even if okay, as a matter of course, it should be mentioned.
Yeah,
okay.
It should also give a reason for that particular dissent.
Thank you.
So provision under the Companies Act 2013 for the minutes, section 118 of the Companies Act deal with the minutes preparation and what are the provision for the minutes for the board meeting, for the committee meeting, as well as for the general meeting. And under section 118 subsection 10, it also states that whenever a company has been preparing the minutes, it has to look into the Secretarial Standard 1 and Secretarial Standard 2. That is Secretarial Standard 1 for the board meeting minutes and Secretarial Standard 2 for the general meeting minutes. So whenever the company has been drafting a particular minutes of their meeting or the committee meeting, so they have to always keep in mind that they have to follow the specific guidelines or the general content of the minute of the SS while drafting the minutes. And if they're not complying with that particular, so it can be a non-compliance of the section 118.
Siddharth, go a little slow, huh? Please.
Okay, ma'am. Okay.
Yeah.
Points to be remembered while drafting the minutes as per the Companies Act. So these are the particular certain points which is to be followed by the company as per the Companies Act. Minutes should always contain a correct and a fair summary of the proceeding. All the appointments which has been made at the meeting should also be included. The appointment should also specify the date of a particular director or a company secretary or a KMP who has been appointed at a particular meeting. The name of the director present, the assent and dissent given by the director for an agenda which has been put for the meeting, as already discussed, a doubt on by the solicitor. Tampering of the minutes has been not been allowed under the Act.
1 minute. Now, this first point, fair and correct summary, is a real challenge. And if you remember, Silas Bhai, we have specially mentioned that chairman should summarize at the end of the discussion
Yes.
the matter to be included in minutes, because this was specifically added because there are in meeting so many discussion happen. CS has to capture. If it doesn't capture particular thing, then the same will be questioned. So it will left to the judgment of CS and unnecessary problem and blame game on CS. To avoid that, I request each CS, even though chairman skip that, request chairman, please summarize what to be included in minutes. If there are many hot discussion, normal topic you can of course man, but when there is a discussion, please request chairman, summarize the discussion which will be included in minutes. This saves the CS. Yeah, please go ahead.
Every minute should be made properly, and it should be kept in the minutes book within 30 days from the date of the conclusion of the meeting. The company is also required to record the summary of the resolution if the meeting has been held through video conferencing. So nowadays, a lot of meeting due to the pandemic situation, a lot of meeting of the company has been conducting through the VC. So it is the duty of a CS or anyone who is drafting the minutes to record the summary of a particular resolution. As Judge Dipti ma'am discussed about it, it is a very important aspect that a summary should be given after a resolution. Circular resolution.
There is a question in chat box, if can be attended. Mr. Bala, there is a question in chat box, please. If you want to, or panelists want to answer. This is as regards video conference meeting only. That's why I pointed out. The question is, due to deletion of rule on video conferencing, does this mean that now all the meeting can be online? Are you specific as regards extraordinary general meeting, Mr. Mukesh? Because there is a confusion over extraordinary general meeting. Only board meeting. Okay. Yeah, board meeting can be because of this pandemic and all that. Is the assent of the directors for a particular resolution should also be quoted in the minutes? Not necessarily dissent. We can write that assent of, yeah, please.
Dissent only is required to be quoted. Assent is not, because what happens is, except that person, the unanimously, everybody passes the resolution passes unanimously. If the assent is recorded, only the assent is recorded, other people have passed. If the majority passes, the resolution stands. So only dissent is to be recorded.
Mr. Bala, as regards earlier question, would you like to add something? They are asking due to deletion on rule on video conferencing. Does this mean that now all the meeting?
Yeah, that is, you have a choice. You can conduct all the meetings also on the video conferencing if you require. There is no problem. Subject to the procedural compliances, it can be conducted.
Okay. Okay, Mr. Siddharth.
Minutes will, as we saw that section 118 subsection 10 state that the company is required to follow SS1 and SS2 while drafting the minutes. Whenever a decision of a board is based on a presentation or any unsigned documents which were not a form of the notes or agenda. So the same should be mentioned in the minutes and it should be signed by the chairman or the CS of the company. The secretarial standard. So we should discuss some of the secretarial standard points, that is the specific content and the general content while drafting the minutes. General.
Siddharth, one more thing is about the secretarial standards. Just I would like to add that the same are not applicable to that OPC and Section 8 company. So
Yes.
while drafting, some of the big, there are very big companies like Section 8 companies, like Warren Diamond Bose. So we need to also consider those things while drafting the minutes.
Yes. The general content of SS1, the company can maintain the minutes in the physical as well as in the electronic form. The pages of the minutes should be serially numbered and it should contain all the like date, the format, date, the venue of the meeting, the time of the commencement of the meeting, and the conclusion of the meeting. Generally, there can be some part where it will be some of the things are missing, but the SS state that such things should be specifically mentioned under the heading of the minutes. The minutes shall record the name of the director who has been physically present or through the electronic mode, and the company secretary and the invitees who has been present in the meeting. The specific content of the SS. Besides the general content, there are some specific content which is to be mentioned under the minutes. The name of the director and their modes of the attendance if they are present through the electronic mode. That is, a director can be present through the audio visual mode or a visual mode or only just an audio mode. So it is the duty of the CS to mention the particular mode of their attendance. In case of director participating in the electronic mode, the particular location. For example, if a director has been participating through the electronic mode, if he is present, if he is present from Mumbai or from Lucknow or from Chennai, so it is the duty of the CS to mention that particular location of the director, the name of the company secretary who has been attending, and the invitees and their mode of attendance is also to be required to be mentioned in the minutes. The record of the chairman of the meeting and the quorum which has been present to conduct a meeting. The name of the directors who has sought a leave of absence. Basically, there can be a situation where the company forgot to mention the leave of absence which is given to the particular director. But the SS state that it is necessary to mention the leave of absence for a particular meeting of the director. Noting of the minutes of the preceding meeting, that is the previous meeting, it should be noted in the current meeting. And also the committee meeting minutes which has been held before the board meeting.
1 minute, Siddharth. There is a question in our chat box. Take to that slide only, Siddharth. Is calling roll call compulsory? Is it only for the directors present or also by CS and all other who are present in the meeting, say auditors and other special invitees? I will throw
let me take that question. So
Yeah,
basically
please.
on the practical side of it, yes, roll call, first of all, it is necessary to be taken. Second, it's for all the directors. Say, for example, there are many times where companies have overseas directors as well. So locally, people are able to assemble and participate in the meeting from a particular location. But whereas overseas directors, because of the current travel restrictions, they may not be able to participate. So in that case, we generally have a video conference. It's generally a hybrid, but for recording purposes, it's a video conference, and overseas directors need to make their recording. I mean, they need to have a roll call for them. And it's not necessary for the other participants or the invitees. Invariably, what happens is the company secretary, it's the duty that he says that the other participants for this meeting will be ABC, XYZ, they are going to participate. And while recording in the minutes, you have to be very specific, saying that for this particular item number, so and so invitees attended and participated during the discussion, like for statutory auditors or internal auditor, or if there is a presentation by any business function. So I think, I hope your question is answered satisfactorily.
There is additionally, as mentioned, there are board meetings where chairman does not take roll call, even if clearly instructions are given to chairman. Whether is it violation?
Yeah, of course,
Of
it
course
is in
it is,
violation.
because
So,
really speaking, is very clearly before starting the meeting, the roll call has to be taken, and if people have to be checked whether they are actually audible, able to hear, everything is okay. That is actually required to go in recording. If it is not done, it is clearly a violation.
Violation of SS or any particular section of the Act.
SS is law. As far as
SS
this
is
is
law.
concerned, SS is law.
So it's a violation of SS, you want to say?
No, but SS or Act, SS1 and SS2 are law.
And is there any specific statement the director or the other invitees have to mention that, you know, I can hear and I can see and all the papers are in order and the secrecy will be maintained and all? Is there any specific statement to be made, or just saying I am present from Mumbai, Calcutta, wherever?
no, that is to be specifically mentioned, and that needs to be going on record, saying that apart from hearing and be able to hear and listen to others, there is no other person participating in this meeting. That's also an additional sentence or a statement that has to be made. So it could be like from a residence, the director may be participating. So he needs to make a clear statement that there is no other person in the room from where he is participating in the meeting.
Okay, now my
Bala,
question.
so, Bala, if it's a completely physical meeting and
Yeah.
not all the directors are physically present,
Yeah.
then two roll call is necessary?
No.
No, that is not necessary.
It's not necessary.
If the physical meeting is there, it is not necessary.
It's not necessary.
Yeah,
Okay.
the roll call is necessary here because there are
Yeah.
two issues are coming out. One issue is the other party who's actually participating is able to hear and understand, and he
Yes.
is able to participate. That is one. And second thing, suppose even though your video is on, somebody else can sit next to you, they can hear everything. Board
Yes.
meeting is being a confidential meeting. He has to categorically give a declaration to the board member that apart from him, none else is actually attending the meeting. That is
Correct.
required.
I
These
think,
are the two
I think
aspects which has to come. Yeah.
Yeah,
I
some
think-
practical issues like some directors have got a habit that while they're traveling in the car or traveling by road, and they are also attending. So I think that when the driver is there, so I think that is also amounts to a wrong declaration on the part of the director, because the proceedings are.
Correct. See, tomorrow if the information leaks, if
Yes.
something comes out from there, or any insider trading takes place, etc., and other thing, the investigation goes, they can always find out this.
Right.
Then in which case the wrong declaration, that you will be liable for the action because violation.
Correct.
can I will think whether we take questions later on, because there will be a lot of questions. What do you suggest, panelists?
Yes.
All together at the end, let's finish it off, because I myself has, if you have any comments, I will request everyone, even participants, they can add on comments. But as it has question, I think we'll take later. Even I am inclined to ask many questions. So I think better we take it at the end. Whosoever wants, please put on in the chat, because today a lot of people are there. So chat box, we will take all the question at the end. And all panelists can add on their point during in between. Thanks. So I'm muting everyone except panelists now, please. Yes, Siddharth, go ahead.
Yes, ma'am. Thank you. The text of the resolution which has been passed to the circulation, many of the time the company passes a circular resolution which has been noted in the subsequent meeting, but they fail to add the text of the resolution. So it is important as per the SS to also mention the text of the resolution too. Consideration of any other item other than those which has been mentioned under the agenda. The fact if any of the directors been interested for a particular transaction, and it is also required to mention that such director was not a part of that particular discussion and has been not voted on that particular transaction. The time of commencement and the conclusion of the meeting, the fact of dissent and the name of the director were dissent from the resolution or abstain from the voting thereon, it is to be mentioned. If any director has participated only for a part of the meeting and not for the other part, it should mention that for which part he's not been present. General content for SS2. SS1 was for the board meeting. Now for the general SS2, that is for the general meeting minutes. Minutes states that at the minutes will state the name, the beginning, the meeting, the name of the company, the date, the venue, and the time for the commencement. The minutes shall record the name of the director and the company secretary who has been present. These are the general content which will be mentioned in the general meeting minutes beside the specific content. These are the specific content which is to be mentioned. The record of the election of chairman of the meeting. So in the general meeting, the chairman can be the director or the shareholder. So it is to be it is required to mention the chairman who has been elected. The fact that the registered, the documents and the audit report, the secretarial audit report is available for the inspection is to be mentioned. The number of the proxies and the number of shares represented by them. The quorum is to be recorded and the number of members which has been present and their representative. The presence of the chairman of the audit committee, NRC committee, and the stakeholder relationship committee and their representatives should also be mentioned. The presence of any secretarial auditor and the auditor is to be mentioned in the general meeting. And also, as per the act, if any of the auditor has been provided a leave of absence, so it should also be mentioned under the minutes that the particular auditor has been provided a leave of absence for the particular meeting. The summary of the opening remark by the chairman by reading out the qualification if been any of the provided by the auditor. So chairman is required to be give a clarification or the summary type on a particular qualification which has been provided under the audit report. Just like the audit report by an auditor, the chairman is also required to give a to comment on the observation or any of the comment or the remark which has been given by the secretarial auditor if the secretarial audit is applicable for the company. In case of poll, the names of the scrutinizer appointed and the number of the vote which has been casted in the favor and against the resolution and invalid vote should also be mentioned under the minutes. Summary clarification provided on various agenda should also be mentioned under the minutes. If the chairman vacates the chair in respect of any specific item, if he is interested in that particular item, it should mention, the minutes should mention that particular item. And again, who has taken the particular chair for that particular transaction, it should mention that too. Time and commencement, time of commencement of meeting and conclusion of meeting should also be mentioned. Generally, this was the topic which was discussed by the Dipti ma'am at the starting of the presentation. Can a minute act as an evidence? It is a question that comes in everybody's mind. Can a minute act as an evidence? So for that, we can take a reference of the Evidence Act. So evidence in the Evidence Act, the evidence means any of the documentary evidence or the oral evidence which has been given. And the secondary evidence. The secondary evidence means, as per section 65 of the Evidence Act, it means any of the certified copy, the copies which is made by the original copies, or any oral accounts or the oral communication which has been converted under the document. So minutes can fall under this. That is the oral account which has been converted under the documentary evidence. So it acts as an evidence under the Evidence Act, and it is also admissible under the court of law. For that, we can refer a case study, that is in M. Ramachandra Bali versus M.R. Kanaya. The Madras High Court held that the evidence that the minutes can be act as an evidence, and it is a documentary evidence, and the admissibility can be brought into the question in the court of law for any of the proceedings. Does the drafting of minutes has any specific format? So everyone can get a question that can a minutes can be drafted into the particular way. So what is that way and how it is to be drafted? What is the starting point? This question arises every time. So as such, there is no specific format which has been given under the Act, but the Secretarial Standard 1 and Secretarial Standard 2 provide a standard format for a minutes, which is not mandatory, but it is always recommended.
Yeah, go ahead, Siddharth.
Yeah. So it is always recommended by the SS, the format which has been given under the SS, to be used for drafting of the minutes. How can you rectify the errors in the minutes? The minutes was entered in the minutes book shall not be altered. So this is basically everyone knows about it. But SS states that if any of them, if any alteration is to be made under the minutes, so it shall be taken approval by the board of directors in the subsequent meeting, and such alteration shall be noted, and such alteration shall be signed by the chairman. However, if once that minutes has been signed by the director or the chairman of the particular meeting, then such alteration cannot be done. So this alteration can be only done before the signing of the minutes and from the date when it has been entered in the minutes. So we should always keep in mind, once the minutes are signed, it cannot be altered. General meeting minutes. So as the
Siddharth, if it
Yes,
is
ma'am.
signed, that minutes cannot be altered.
Yes,
But
ma'am.
if the mistake is found later on, then in subsequent meeting, you have to consider it as a item for the
Alteration.
correction of minutes already signed and circulated, and the same should be discussed. It should be part of that particular board meeting minutes. And in that, you can say that this board has discussed the matter, and the minutes which is already circulated, there was apparent mistake here.
Yes,
This should be read as this and should be amended as, and this will be the final minutes, and it will form part and parcel of that minutes. These when you draft, then it overrides that.
Who should sign?
Sorry.
Who should sign that changed minutes or maybe corrected minutes if the director is not there at all on the board or who was the chairman at that point in time?
So
I think this question can be asked differently. The same question, Dipti, when such a resolution is passed, it's decided to amend the earlier minutes. Do you go back to those minutes and make a change in those minutes?
No. It is like a new item in this board meeting.
And therefore, the old meetings have to be read along with this, is it?
Right.
You don't make a change there. If there has been, instead of Rajadeksha, it should have been Bala. You don't cut Rajadeksha and write Bala.
No. You don't make a change in that minutes. What you do is you actually note the mistake. You schedule an agenda item in the next meeting.
Yeah.
That is saying, rectification of the earlier minutes which are to be corrected. Then you take that item, you discuss it, you record in this minute, this parts form up those minutes, because you say here, which was actually earlier recorded, this is erroneous, it should be read like this.
So how far it can go back? How far, if you are in the last quarter of a calendar year or financial year, and if it comes to the first quarter of financial year, some changes, can you go that back?
You see, there is no limit as such.
Yeah,
it's
correct.
a kind of thing that you have found out via media, and you have rightly raised the question that in that meeting, suppose 4 directors are there, and when you are rectifying, I'll put that way, same set of board of directors are not there. If the same set of board of directors is there, it is understood that the same set of board was there. They have been informed that we are discussing this, these are the correction. They discussed and finalized. But if the same set of board of directors are not there, then how much binding it is, it's a matter of question. In that case, even the directors who are not part and parcel, you can inform as a governance practice and do it. There is no law as such, but as a matter of justice, equity, and to correct, you can take this via media and putting this.
So maybe in that meeting, one can mention that since Mr. So-and-so is not a director on the board now, he was a chairman. So in his place, it is required to be initiated by the then chairman. Now the power is given to the present chairman. Maybe it can be written like that also.
No, not necessarily. I'm not talking that chairman portion. It will be like board meeting and minutes of that meeting. It will be follow that process of signing and chairman by signing of that meeting only. I'm telling that there is a mistake in the meeting minutes in which A, B, C, D 4 directors were there. But when you are correcting, only A, B, C is there and E is added. In that scenario, if it is ABCD, both are correcting their own action. So each one is involved with their own consent. They are discussing and finalizing. But if it is A, B, C, E, so E is new person, D who was part of that minutes and mistakes, E is not there, then you are correcting. So in that case, how to handle and how it is, as a matter of justice, equity, governance, I told that. Otherwise, it will be that 2 minutes. Please note that no written rule or provision or kind of is there. But since this is the only way you can say that if a person who has right to add or reduce, it is just that same meeting, same director, same authority, that is board.
But there is no question of any initialing or anything because you are not going to write on top of the
No,
whole
no, no,
minutes.
no.
No, he was asking whether the chairman can initial. No.
If there is an error, say by mistake in a financial year, for example, instead of 21-22, it is mentioned erroneously as 2021. Now that mistake has come to our light now. So it has to be rectified by putting the correct year. Now it has to be initiated by the chairman.
No, but as I asked and as everybody clarified, you don't go back to the old minutes, cancel 2021 and write 21-22. No, you don't do that. So the question of initialing doesn't come. It is only the current meeting which will pass a resolution saying that there was an error in the minutes of that, and that 2021 shall be read as 21-22.
No, Sailesh bhai, he's referring, I think, to correction of minutes, and chairman of that will initial value do correction.
No,
He's
that is at
referring
the
that
immediate
for-
meeting. But that is at the immediate meeting. If this error comes to the notice after say 1.5 or 2 years, then you don't go back, as you just said, you don't go back and make a cancellation there and write on top of that. No, you do it by way of a new resolution.
It's kind of a ratification or maybe correcting the earlier minutes by passing a
Right.
resolution.
Yes, exactly,
Okay,
exactly,
Okay.
exactly,
Okay.
exactly.
Well taken. Yes.
Okay, okay, Siddharth, go ahead.
So there can be always a problem that error can be there in the agenda item. So how to rectify that error? So SS also give a highlights on that point. If any of the error which has been there or a grammatical mistake or any in the has been identified in the notice of the agenda, it should be rectified and intimate to the members in a form of an erratum. And such erratum may be circulated to the members at the general meeting itself. However, if such error is in the text of the resolution of any of the agenda item, it should be notified to the member as soon as they find it out. So it is necessary that if any of the error has been there, it should be made known to the shareholder that particular error has been there under the agenda and it should be rectified. However, if such agenda item is put for the voting, so then it cannot be rectified.
One thing I want to add here, again, getting back my overseas experience, I've been working in the Kingdom of Bahrain, and also I was actually associated in Tanzania and Kuwait. These places, when the board meeting actually takes place, they were actually following what you call the governance code of this one, what you call King's 2 of governance code in those countries. And Bahrain, of course, they were following the UK corporate governance code. So here, any particular board meeting take place, after the election of the chairman and the quorum, the next item which is discussed is to discuss the agenda item and agree for the agenda item is the item which is actually discussed. Although the agenda has been circulated, all the directors will go through all the agenda items and they will see, okay, everything is okay, we can discuss. Then the chairman will ask, anybody has got any other item to be added? That any other item is also added in the beginning only. That's all. Then you say, okay, this is the approved agenda. This is the any other item which will be there. We will discuss. Then once that happens, that is the end of the meeting. That is one of the practices which was actually followed in this country.
This is
So-
actually good practice. Otherwise, so the board is ready that this new item will be discussed. They can
Yeah.
think something. Otherwise, what we do in our case, entire meeting is over. Okay, there is some item is there.
Yeah, last minute we have this item, we have this item like
And
that.
the board is not mentally in a mindset to discuss things, and they think that meeting is over, also in a relaxed mode, and that get closer. I think this is a really good practice, huh? Sailesh bhai, this should be in secretary standard. It's a very good point.
Now it's up to you.
No, we are also out from secretary standard.
Yeah,
Thank
you are also not there. Yes.
Yeah, Siddharth, go ahead.
So as we saw that the minutes drafting important, it is also to know that how to draft a resolution and what are the importance of the resolution, because the resolution are the part which forms the part of the minutes. So it is also important to look into this matter too. So why it is important? Because the company is an artificial legal person, and the owners are the members, and the directors are the authorized representative of the members. So the director take that decision. So how can a director take that decision? So director take that decision by passing a resolution. The resolution contains the action from which such decision has been arrived, and it specifies the day-to-day function of the company, that how particular decision has been arrived. So it is importance of the resolution can be derived from this particular point. Points to be considered to draft a resolution. All essential facts should be included in the resolution. The resolution must indicate the relevant provision of the act as well as of the rule. The resolution must indicate when it will become effective. For example, if an additional director has been appointed in a particular meeting, so it is necessary to mention that from which date that additional director will be effective on the board. So it is necessary to be mentioned because such date is to be also mentioned in the form, which is to be filed with the ROC. So it is important to mention that particular date. Resolution should be confined itself to one subject matter only. Company should not take too many agenda items in a particular resolution. It should only have a specific one item for a one resolution only. Resolution should be crisp, concise, and precise, and should be flexible enough to take care of the eventualities. For resolution should be drafted in such a way that it should think of all the possibilities and all the possible areas which can touch by a particular agenda item. So the company secretary should keep in mind that all the possibilities should be taken care of while drafting the resolution. Surplus and meaningless words should be avoided as it can create a problem in future. Reference of document approved at the meeting should be clearly mentioned. Resolution should mention the assent and dissent of the board members and also the committee members. How to draft a resolution? The resolution should always start with the word resolves that. As a resolution it is an agenda item which has been put for the voting and it has been resolved by the members. So it is necessary to start the word with resolve that. The company cannot just draft a resolution with it has been approved or either like that. It should be always start with the word resolve that. It should mention the provision of the act as well as the rule or any other act from which a particular is been derived. If a resolution specify any authority, it should mention the authority. For filing of the ROC form, it should mention the signing authority. The signing authority which will use to file the form. By adding a word further resolve that. One should always use proper punctuation to make the resolution more effective and that it can act as an evidence in the future. Time limit within which the draft and signed minutes shall be circulated. As it is an important concept, we should look into the matter. The SS emphasizes on how the meeting draft minutes and the signed minutes should be circulated to the directors. The draft minutes shall be circulated within 15 days from the conclusion of the meeting. And if any of the director or any of the committee member who has any opinion on the particular draft shall comment on within the 7 days from the circulation. So we can look up for the example from here. The date of the meeting is 1st September 2022. The latest date for the circulation will be 15 September 2022. And the comments of the director, if any, shall be given by 22nd September 2022. If any of the director has not given the comment, it will be considered that such draft has been valid and it has been approved by all the directors.
I have a point here, Bala. Bala, when these draft minutes are given, and within 15 days they are received, the comments are received.
Yeah.
Within 7 days. No, within 7 days
within 7 days.
Within 7 days, comments are received from the directors.
Yeah.
One of the directors mentioned the comments are then given. If there is a comment from a director, it is shown to the chairman, and if the chairman accepts that yes, this needs to be changed, that change is made. Now, is it not incumbent that the minutes, or at least this point, be recirculated to all the other directors? There is no provision in the secretarial standard nor in law on this. Have I made myself clear, Bala?
Yeah, you're absolutely right. I have come across this situation actually in the practical life. What we do is normally we circulate the minutes in 15 days. And within 7 days, when the comments are received, then it is discussed with the chairman, and ultimately the minutes are redrafted again. The redrafted minutes are again sent to all the directors for their information. That is the practice I've been following it actually.
That's a very good practice. That's a very good practice that you are following. But then does this period of 7 days kick in again?
No, because it will not kick in again. But only thing is the chairman wants, he can allow. That provision is there.
It is very fair that he allows, but
Yeah.
the chairman makes a change, say on
Yeah.
the 24th day.
Yeah.
He makes a change
Yeah.
on the 24th day.
Yeah.
Then will the directors get another 7 days to decide whether that change is okay or not?
I don't think that law is there.
There's
provision.
nothing. There is
Yeah.
nothing.
Yeah.
What
is
you
not
do is
there.
absolutely correct. You should do it.
But
You should do it.
But one more thing is there. I normally used to follow this practice, as I told you. Second thing is there. Then what happens is only the provision which is there is after the minutes are signed, only the signed minutes are circulated. But before the minutes are signed, here again,
Yeah.
coming back to one more thing with my overseas experience only, I can tell you. Overseas experience also, we've been following this practice. But even though this practice has been followed, we normally say in the next meeting, the last board meeting minutes are confirmed. But the practice which was followed there virtually, it is my experience. Virtually, the minutes were read in the meeting actually. In the next meeting, virtually the minutes are read. In fact, we used to record there the minutes which was earlier circulated is read, gone through by the director and confirmed and then signed. So
But
at that point of time, they had anything to say, chairman can actually admit the corrections.
I feel that something on this, Dipti, we have missed this in our deliberations. Something on this should come in the minutes. How to deal with changes that are suggested by directors.
Sir, in my view, can I have my view? In my view, what happens, the changes which requires to be done later on beyond the statutory period of SS1, I think needs what Mr. Bala said is to be recirculated, because the other directors will never able to know what is transpired and what is approved by them has been changed. So
Yes.
it is always better to recirculate the same with the comments put in the mail or whatever communication you are having. I think that will solve the, at least that will be transparent to all the directors.
No, I think that's absolutely right, but I feel that there should be some indication about this in the SS1.
What Sailesh Bhai is saying is that there need to be a legal sanctity should be there. It should allow that time. That's what he is saying.
Something you should introduce this, give it instead of 7 days, give it 2 days or something of that sort.
Okay, that the authorities has to take care of this, and
Yeah.
institute can at least recommend this to the government for the same.
Dipti and I have been in the committee that drafted this. It has missed us actually.
Yeah, today it is not there, Sailesh Bhai, as you rightly said.
Yeah,
Yeah,
it's
yeah,
not there. It's not there. It's not there. Yeah. Okay, please proceed, Siddharth.
The minutes, once it has been approved by the director, it shall be entered in the minutes book within the 30 days from the conclusion of the meeting. The signed minute circulation. Signed minutes shall be circulated within 15 days from the date of the signing, and each page of the minutes shall be initialed by the chairman. So we can take up an example here. The minutes, as we saw that our meeting was held on 1st September 2022. So minutes should be entered by the latest by 30th September 2022. And the date of signing shall be the next board meeting probably. So if the next board meeting is held on 1st December 2022. So the latest date of circulation of the signed minutes should be 15 December 2022. So that the signed minutes shall be circulated on or before the 15 December 2022.
Siddharth, here, the minutes also can be signed by the chairman of the meeting who held the meeting earlier than the next board meeting also.
Yes, sir.
Yeah, on the earlier point, Sailesh, by what we're discussing about the comments and all that.
Yes.
Actually, also we are handling the Section 8 company, which is having 40 directors, and everyone is giving their comments.
Yes.
Now, there will be comments on comments.
Yes, correct.
You have to allow that as a healthy practice.
Yes.
Otherwise, it will be questioned. So what we used to do, we used to circulate each comments the moment it is received to all the directors again. So if they have comments, of course, nowadays, that software is there and the board on the, specific app is there and all that. There, everyone can view the comments of everyone and accordingly give comment. So not only the comments, all directors also should know what other director has commented.
Exactly,
And
exactly.
because before changes, other directors would like to know. So better way of doing is that each comment should be again circulated, and it become real challenging. Comment on comment on comment.
Correct.
It reached 4 comments on each and everything, and then we analyze, we finalize, and then chairman finalize. So
And,
it's
and you see the number of days remaining is also small because 15 plus 7, 22 plus 8.
that also you have to remind. That also you have to remind
Yes.
to all directors that this timeline is over. Now we have to finalize. So
And-
that is a momentum actually it reached to particular stage.
Correct,
So
correct.
that of course you have rightly mentioned there is no provision, but as a governance and as each
Yes,
director
yes,
know, we should follow that. But you are right that there should be some provision. So
The-
we have a true secretary standard suggestion. Okay. Okay, Siddharth, next.
So this is the consequences for non-compliance of section 118. So if there is any consequence in the in default in the provision while drafting of the minutes, then the company will be liable for a penalty of rupees 25,000, and the officer in the default will be liable for a fine of rupees 5,000. A person found for tampering of the minutes as per the proceeding of the meeting as per section 118, the fine should not be less than 25,000, which may extend to 1 lakh, and it depends upon the authority for imposing the fine. The important point, that is the preservation of the minutes. The board meeting shall be preserved permanently. It can be preserved in the physical form or the electronic form with the timestamp. However, when the company has been maintaining the minutes in the electronic form, it is necessary that the company follow a particular format of maintaining the minutes. If it is under the electronic form, it should be under the electronic form in a consistent manner. If any deviation has been required, so then the permission shall be taken by the board for that. The minutes are also be permanent records as per Rule 25(1)(d) and E of the Company Management and Administrative Rule. General meeting minutes, as same as for the board meeting minutes, the general meeting minutes shall also be preserved permanently, and it can be also be mentioned under a physical form or the electronic form. Wherever there is a minutes is to be formed under the electronic form, the SS specifies some of the 3 points which is to be kept in mind while keeping under the electronic form. The information content should be readably accessible so as to be usable for the subsequent reference. It should be written in the original form. If it is not possible in the original form, it should be as similar to the original form, the details of which facilitate the identification of the origin, destination, date, and the time generation available for the electronic record. It should also mention that when the such particular minutes is been generated, and when it can be available for the records. Even the SEBI specified that even the SEBI has some points that the minutes shall be preserved permanently, as it has been covered under the regulation 9 of SEBI LODR, and a company is also required to prepare a policy for the preservation of the documents of such document, which shall be approved by the board of directors.
Not only that, it is also required to be placed on the website of the company.
Yes, sir. There are some case studies which is to be discussed. This is a recent judgment which has been given by the Calcutta High Court. In this particular case, the Usha Martin Telematics Limited versus the register of the companies, where the company passed a resolution for the deregistration of the NBFC and for the registration as a CIC. But at that particular point, the company was not registered as an NBFC. When the ROC inspected the books, that is the minutes book of the company, they found out this point, and they asked for a clarification on such point by the company. And the company provided a clarification that they have been altered they have rectified the error in the meeting, which was in 2015, and rectified the error and said that it was not a negligent error, and there was no any malified intention, as ROC was not satisfied by the particular reply or the response. They filed a case under the special code for the offense under section 118 and 447 and 448, with the special code pass an order under the favor of the ROC. But the same was challenged in the High Court of Calcutta, in which the High Court found that the error was rectified by the company, and the company does not have any intention or a malified intention to default any of the stakeholder. And at the time of such passing of the resolution, it was not registered as an NBFC. So there is no point of default. So such case was quashed by the High Court and the special court. So this is the timeline in which the case flows. That was 11 June where the preparation of the minutes were done, in which the error was been made, that is for the deregistration as an NBFC and to convert into CIC. 9 September was the date where the error was rectified. Even after a long time, like a 1-year gap, the error was rectified. And in February 2016, the books were inspected by the ROC. And 21st August, ROC issued a notice to the company for the reply in the same. And 20th September 2018, the company gave a clarification of the same, which was not satisfied by the ROC. And 27 January 2021, that is last year, the Court of Calcutta passed an order to quash the cases, as it was not a malified intention of the company to defraud any of the stakeholders.
I'll give you the small insight of this particular case. You will be wondering how this has happened actually, many of you. Especially for the youngsters, I want to share this. This company, what he is referring, is actually one of the Vodafone Group company. Vodafone Group, when they acquired the SR, they not only acquired the Vodafone, they acquired around 15, 17 companies from them, which are various other companies like investment company, NPC company, cable networking company, etc. and other things and all. After that, there were about 4 NPC companies they have acquired. And this company is not the NPC company, but they are actually subsidiary of one of the parent company. And normally in these companies, what happens is the agenda items are common, more or less. Only thing is the NPC company, to that extent, the agenda item differs. Here, what the company secretary, he is being a parent company secretary and also a subsidiary company secretary. He adopted the minutes of the company, which is actually having a NPC. Item is being the common. He simply copy pasted this item, inadvertently appeared. That is how this mistake has actually happened. So the copy paste is one of the things which is actually killing us if we actually don't go through and take enough care to see the right things are actually talked. That is how this is occurred. I know this.
Very interesting. Thanks for inputs.
Yes, very interesting input.
नकल में अकल वापरनी है अपने को. That's the underlying.
Okay, Siddharth.
So these are some case studies which shows that how minutes can act as an evidence. This is a case B. Sivaraman and others was the Egbert Benefit Society Limited, in which it was held that by the Madras High Court that the minutes shall be, if the minutes are not kept as per the act, so that minutes cannot be act as an evidence and it cannot be brought into the court as an evidence. So this is emphasized that the minutes should always be prepared as per the act, that is as per section 118, by keeping in mind the secretarial standard as well. The second case study, that is Escort Limited versus Sai Auto, it says that the resolution passed at the board meeting in the minutes book in the particular resolution was recorded should be produced before the court as an only fact of the evidence of the case and was passed in the board meeting. This says that the only resolution which has been recorded in the minutes, it can act as an evidence, and only that resolution can be put as an evidence under the court of law. These are some recent judgment or the adjudication order which has been provided by the ROC of the various ROC of the state, in which the company was in non-compliance of section 118 subsection 10. That is, the minutes of the company was not as per the secretarial standards. So in the Indabulls Real Estate Limited, the company did not follow the secretarial standard for maintaining the minutes. So the company was charged a penalty of rupees 25,000, and every director of the company was charged with a fine of rupees 20,000. So total the penalty which was charged was 1,60,000 for all. In the Neurosis Consulting Service Limited, even in that case, the company passed a circular resolution for the approval of the financial account, which has been restricted item under the SS. And in this case, the company was charged a penalty of 25,000, and the officer in default was charged with a penalty of 5,000 rupees. So from these two case studies, we can emphasize that how secretarial standard is important and how secretarial standards should be kept in mind while drafting the minutes of a particular board meeting, committee meeting, or the general meeting.
Very true. There is very little in the Act as such on minutes, and it's really very well covered in the secretarial standard, para 7 of the board stand SS1, and one needs to follow it very carefully. Yes, there's no denying that at all, because the Act does not have much about minutes.
Even here, this is a particular case which emphasizes on how a resolution is important and why in a resolution a particular section is to be quoted. In this case, the Valley Monks Private Limited, the company passed a resolution for a private placement of their CCD, but failed to mention the section number 42 of the Companies Act, which create a problem for them. And at the same time, they were delayed in filing of a special resolution. So in this case, ROC Bangalore charged a fine of rupees 1,50 lakhs. That is for 50 lakh for the company, 50 lakh for the full-time director, and 50 lakh for the director. So even here, we see that the drafting of resolution is also important. Not only we have to keep in mind the minutes drafting, but also the resolution drafting, and also mentioning all the relevant points, the facts of the particular cases in the resolution. That's all from my side. If anyone wants to put their inputs or any of the question, so they can just put their question in the chat box or unmute and unmute themselves and say.
Very well done, Siddharth. Thank you.
Very well presented. Especially the case study was very good at the end, which you brought in.
Thank you, sir.
Wonderful presentation, Siddharth. My appreciation to you. I compliment you.
Thank you.
Siddharth, I think the last case which you have presented is a recent topic, very hot topic among all company secretaries, because the penalty has gone to 1,50 lakhs. I think that is a big challenge for us also while preparing the forms and certifying the forms. I think it's very important to be very careful and not. It's last case, and Siddharth, I really appreciate your very good presentation.
Thank you, sir. Thank you.
So friends, I would just like to add on a lighter side. You spend hours in preparing minutes. Is it not? Very important.
Yeah. We can take the questions and the chat backs, and then later on everyone can also personally add the point. Let's take one by one the question. The first is there was from Mr. Mukesh, whether does leave of absence has any relevance, because if any director does not attend for a year, he automatically becomes disqualified even if the leave of absence was granted. Now, here I will add that why leave of absence is crucial. That shows, you also note down that it shows the care director is taking to attend, or if he fails, then he asks the leave of absence, not abruptly does not attend. This is a sense of responsibility. Please note that each thing is counted. So yes, whether leave of absence given or not, it's not asked, fine. As you rightly mentioned that it is disqualified, because as we know many times, even though leave of absence is not asked, we will give it so that director does not disqualify. So, but according to me, legally you can say, but as such, it is always noted and we grant leave of absence. This is a trend followed, and it's a respect kind of thing that you note down the absence of a director and he asks this. So yes, it will, I will put that way. Now it has not that legal relevance. I will suggest if any panelists want to say, add on something. Okay.
Directors are expected to devote enough time to the company where they are appointed as a director. And he is also duty bound to appoint the meetings. By any exigencies, etc., he is unable to attend the meeting, etc., and all the things, then he takes the leave of absence, which is actually granted. That is the primary purpose. As you rightly say, he's for the name, he's a director, and he doesn't attend and he doesn't devote the time and all the things. Really speaking, that doesn't contribute to anything.
There is another question from Mr. Kunal. As per SS1, minutes of board meeting should be signed before the next board meeting. by chairman or by chairman of next board meeting in ensuing meeting. In current situation, sending minutes to the chairman is not possible. The meetings are concluded in VC mode and the chairperson elected at meeting in VC. So signing is difficult within specified time. Is there any solution for this current situation? Panelists, please.
I'll take this question, but I don't see what the challenge is. Basically, although we may be virtually connected, but there are papers papers do come across, and courier services are also available. So I really didn't understand the challenge. Maybe
I also do not know what is the challenge in this. In fact, the chairman who was actually elected, who was attending the board meeting from UK, and meeting is concluded. After that, when the minutes are over, then we actually courier it to him. He actually sign it and he sends it back. I don't know what is the difficulty here.
I'm also of the same view, sir, because we did recently in German company's case where we could send it to Germany in time and we got back those papers also in time. So
Yeah,
if
that
it
is what
is,
normally it is followed by but that is what normally it is followed practically.
right.
Here I don't understand.
Sir, one can I add that leave of absence because which is very important. Suppose the director, there are cases around where this is taken advantage by the other fraction of the directors also. Like he has not remained present for consecutive 3 meetings and he has been removed as a director of the company. So there are cases filed in the register of companies for removal of director based on this leave of absence. So the other this dispute basically is of that we have sent a notice and he has not attended a meeting and he's been removed due to this section. So we have to be very careful while even drafting and even sending the notices to the directors, as this is another chapter and another case law which is going on at present in various register of companies, because there are fractions and there are disputes and directors come and they take advantage of this section.
Next question, Mr. Bala have raised. If 2 meetings are held within a gap of 1 week, whether both previous...
No, sorry. Somebody has asked the question. I wanted to reply some other, while replying, copying by mistake, it has gone. The question is asked by somebody else.
Okay. If 2 meetings are held within gap of 1 week, whether both previous meeting be placed subsequently in later meetings. Panel, please.
No, it has to be taken in the subsequent meeting only because the meetings allows you to drop the minutes 15 days and 7 days to receive the comment. The minutes are not finalized. So if you are having a consecutive within a week, it is not necessary this meeting is to be placed this minute. This minutes should be taken in the next meeting once the minutes are actually circulated and comments are received and finalized. That is what it is.
Practically that's how it happens.
Yeah, that is what practically is also done.
Yeah, there is a question from Mr. Keval. If we want to change the venue of the meeting, can we do it? And how to record it in minutes?
See, basically, when we are issuing a notice, there would be definitely a reference given, either it's through a virtual mode or through a physical meeting at a specific location. And in case if the location is changed, finally the minutes would carry the place from where the meeting has happened. If it's a virtual, then the question doesn't arise. And between the practical, between the meeting actually being held and the notice being issued, there would be a subsequent communication to the board members saying that the meeting venue has changed, if at all, if it's a physical meeting. So whatever goes into the minutes will be the final place where the meeting has happened. So there's nothing to specifically otherwise record that it was originally planned to be held at so-and-so place and subsequently it was changed.
So, but what is his question is that suppose the venue is required to be changed, then we can do it and how it can be recorded. Because if it is board meeting, I can understand, I think you can reach it out also with the shorter notice. If it is AGM or general meeting, then it's a problem because you have to give the notice in advance. If you have sufficient time, you can circulate. I think it is news. Mr. Bala, your inputs or any panelist, please.
Yeah, board meeting, as you rightly say, it is correct. But as far as the general meeting is concerned, it is very difficult because it is not, because the 21 days notice and giving the place, date, venue, etc. is there, and especially it will be a listed company means it will be a hell of a lot of a problem.
No, moreover, the entire notice is approved by the board of directors.
Yes.
So the notice carries the date, time, and venue. So if there is another board meeting and there is sufficient time where the 21 days notice, or that's 21 plus whatever 3 days, if that can be met, then it can easily be changed. That should not be a problem at all. Because
If
So
it
it
is
cannot
done
be-
sufficiently, because normally what happens is board meeting, many companies, they finalize the results immediately within a month or two, but somehow the annual general meeting is held after 2 or 3 months. In such a time, as Mr. Sunil says, if a sufficient time is there, then again it can be discussed with the board and it can be changed. Otherwise, I doubt very much. Yeah.
And also the electronic voting is also involved for listed companies. So
Correct.
that is another big challenge to the companies actually.
I think I can add one thing, that suppose there is some emergency, like that venue has some, natural calamity on that. In that scenario, I think immediately you can have a board resolution circular and then newspaper and sufficient publication. If that situation where it is out of your control, then newspaper advertisement, if listed company on the BSc website, also your own website, so far possible, you can do it. That is something is there, but otherwise, as rightly mentioned by our panelists, it should be board meeting properly, and then if sufficient time, proper notice to again everyone in case of general.
But Bala, in the case of a board meeting, if the
Yeah.
venue of the board meeting is changed,
Yeah.
how would you procedurally go ahead? You would send an email to all the directors and get their consent or something like that? Because
Yeah.
even for a board meeting, there is a time limit of the notice and the agenda
Yes.
paper. How would we go about?
No. See, 7 days before you give a notice, that is always the case. Is there if the venue is changed? Only thing is you should be able to communicate the change of the venue to all the directors, whatever the means, whether electronic means, physical means, or telephone, whatever it is, it should be there. That can be done. And in the appointed date, in the different venue, the meeting will be held. The minutes will record actually. That
The
is-
minutes should also
yeah.
record. Correct.
Minutes will record.
Yeah.
And shorter notice consent kind of thing.
And
we
again,
can-
shorter notice consent is also there in the.
Shorter
Companies
notice
Act.
consent should be taken. Correct.
Yeah.
Shorter notice
is there.
consent should be taken.
Because
Yeah.
notice includes venue also, so
Yes.
it's
Yes.
somehow shorter.
So
That's-
it's not all that simple again for even for a board meeting. There are some
but
processes
it's
to be
still
followed.
possible.
Correct. As far
But
as
it's
the board
possible.
meeting,
It's easily possible. But,
far as the
but the
board
processes
meeting-
should be followed.
as far as the board meeting is concerned, it is possible, but only thing is procedural aspect is to be followed.
Correct.
But as far as the general meeting is concerned, I don't think it is, except as Dipti puts it, it is a exigencies and emergencies which is out of your control. Then only those things can be done. Otherwise, I don't think it can be done.
Has any of the participants in this large group today faced such a situation where the venue of the annual general meeting was subjected to a fire or something like that? Is anybody has this experience? I don't have.
I think in one of the listed company it happened and some permission was not given or something, they expected more people and then the change and immediately in newspaper it has come and all that happened. I remember like it happened and in the newspaper they have given. On the website and everywhere. It repeatedly appeared in 2-3 times.
Repeatedly. it appears.
Sir, I will recollect the years where physical meetings were conducted and there was a dispute of some laborers where we have changed the venue last minute and it was intimated to the stock exchanges. I'm talking of the physical era days. And chairman was also taken in the protection by the police. And then we have conducted the annual general meeting because of the workers' agitation. Around 1,000 workers were present at that particular point of time. So later on, the rest of companies have also issued a notice to that effect, that why the change of venue was done. But because of the extreme contingencies, we have pleaded that this is a real problem and there is a threat to the life of the chairman. And in view of them, they have not taken any action. But it was a very unusual scene on those days. But I have not come across recently any such case. But Dipti said she had one recently, some issue had there. So
No, earlier, but not recently, earlier, physical era.
Okay.
Thanks for input. This is interesting what you have added.
Because I travel in that police van actually, so to be honest with you.
Great.
Okay.
The
This adds
occupational
to
hazards of a company secretary.
Yes, yes.
it adds when we are such a seniors with us in this webinar. Thanks. Mr. Jeevan has raised the question. Welcome, Jeevan, after a long time. What is one director get a personal call during the meeting and he leaves the meeting room? After 20 minutes, he comes back to the meeting room, and if one resolution is passed during his absence, can he raise the issue afterwards saying that that matter was passed without his consent? Panel, please.
What is the question, Dipti?
What is, in case that suppose one of the director gets a personal call during the board meeting and he leaves the meeting room. After 20 minutes, he is coming back to the meeting room. And if one of the resolution is passed during his absence, can he raise the issue afterwards stating that the matter was passed without his consent?
I don't think so, because voluntarily he went out, and so as a writing of a good minutes practice, I think we should also make a note that in this resolution so and so just went out, and then he came back. I think many company has a practice of writing this, that so and so directors moved out of the meeting and he joined back again. So tomorrow he cannot.
Just to echo what you are suggesting, it can be a good practice to mention in the once the director is back in the meeting room by the chairman or by the company secretary with the permission of the directors. Okay, this was the discussion taken place when you were not in the meeting room, and this was a decision taken by the other directors. Then if he has something to say on that particular decision, maybe he can say his words. Okay, this is what, whether he's in favor or he's against that particular resolution. And secondly, he always stands a chance to give his presentation when the minute is circulated to the director as per secretarial standard. So as a good governance, maybe chairman can brief him in his absence. This was what was discussed, and this is what decision has been taken by the other directors. If he has something to say on that, then the company secretary should take it on record at the time of making minutes.
I would say in this situation, when this person leaves the meeting, does it result in absence of quorum? Were there only so many directors that you were at the margin and this man goes out, so there was absence of quorum? If that is the case, or if the article say that so and one person from this party must be present at every meeting, if that is again the case, then there is an issue, because then you cannot take decisions. But if
then
not,
I think the meeting should be
halted until he comes back. Yes. Until he comes back, the meeting should be halted really, and then no decision should be taken. But this does not seem to be the case in this particular issue. So I would say in this particular issue, it should be noted. It should be noted in the minutes that he was not present when this decision was taken, because the standard says that those who voted against or those who refrained from voting should be minuted. Here you should minute this as refrained from voting, or was absent, or something like that should be mentioned in the minutes. Then if he wants to comment on the minutes when they come, he can do so.
I have actually not come across this leaving the meeting and rejoining the meeting, but I have actually come across people coming late to the meeting and leaving early with the permission of the chair. That I have come across. Normally we record this particular director is joined only at this particular item of the agenda. So rest of the resolution which are passed before him, that is taken over. As you rightly say, at the time of the circulation of the minutes, if he has got to say any comments, etc., it is taken of the chairman suitably, and accordingly minutes are done.
But I pity the
and
company
here also,
secretary.
as you rightly say, we will have to record in the minute that he left at this particular item, he joined in this particular item. The question does not arise what is again rediscussing it in the same meeting.
So just to add what you are saying, suppose it is a listed company, and then, as per LODR, we are supposed to even send the proceedings of the meetings.
But only thing is, in case of the independent directors is concerned, then in case there is actually a provision in the law, even if the independent directors is not able to attend the meeting and the minutes are to be circulated to him, if the shorter notice clause is there, then he has to rectify all the decisions which are taken by the board. That is there in the independent director.
Very good point. So if the person who has gone out is an independent director, there is another dimension added to it.
Yes.
Because it comes when it is a shorter notice meeting.
Yeah, in shorter notice meeting, it is very specifically mentioned. The shorter notice is given if the independent director are not able to attend, then whatever the proceeding is to be sent to the independent director, that he has to actually ratify. That procedure is there.
So I think we can say rightly, Mr. Amit has mentioned that actually it should be, chairman should be vigilant, and that's why CS, company secretary, should sit next to the chairman. I always suggest company secretary should sit next to the chairman. So
it is always the case, the company
no,
secretary
no, Mr. Bala.
outside of the chairman.
No, I think the chairman should sit next to the company secretary. I would say the other way. The chairman is also comfortable because company secretary has more knowledge on these practical difficulties than the chairman, possibly in some companies.
Because in the boardroom, company secretary place is permanently reserved next to the chairman.
So the CS should be vigilant that if the person whose consent is specifically required as per the JV agreement or article, or if the person is independent director, or if the person is affecting the quorum, he should be vigilant and he should inform the chairman that please, if he comes, this is important, we can discuss other item or we can hold it accordingly advised. So chairman has to act accordingly. And accordingly, it should not hamper the validity by quorum or if a specific person consent or independent director action. And in that case, actually speaking, there is a decency. Generally, directors always mention, excuse me, I need to attend. You can carry on. I'll come back. And when he comes, he asks that the chairman can brief whether you agree or not, or you want to add your pen. This is under discussion. I think this is the right way to put it that way. Right? Everyone agree this way?
Correct. Absolutely right.
Because the agenda item could be as critical as announcing the maybe bonus issue or maybe buyback or some special dividend. If the director is not present at that meeting and the decision is taken, then he may later on, if he objects to it when the minute is circulated, listed company would have already informed to BSE, NSE or wherever.
Better you attend at that time only rather than in minutes. The chairman role is, that's why, very crucial. Correct. Otherwise, you completed the transaction and then I actually little divert from that. Do not agree that minutes is it's a recording. Rather, chairman and CS should ensure that meeting is properly conducted. So correct. Please follow. We have to be very vigilant at that time.
It is not only skill of writing minutes, but also skill of conducting meetings.
Right.
There's a great skill involved in that. If it is such an important
consent of director that in attendance register signing that signature is a right, vigilant mind should be, because whosoever attend, invitee also should sign. So it's a real thing. It's a system you have to follow and educate everyone and director that you have to sign, please. And you have to vigilant, keep in mind he has signed or not before he leaves. That is also very important role. Okay, next.
Thank you.
Thanks, welcome. This is by Ms. Preeti, rectification of minutes, what we discussed. If the original minutes are not changed after approval for change in subsequent meeting, then how will it be known at a future date that a particular minutes were changes? Each minutes are considered standalone basis and every time subsequent minutes will not be checked. Right? I agree, Ms. Preeti. But here, as I said, there is no law. And when you are checking the minutes, its entire minute books comes, and at least these minutes are not given or it's not available to public as such. It is given by the company. So the CS department, secretarial department knows there is a change. So they are bound to inform. It is the duty of secretarial department. Very good question. And if for that reason, if you require, you can also mention at some point tagging that these minutes were changed in this meeting for the remembrance of Secretary Department. Yes, Sailesh bhai.
This is an excellent question. This is an excellent question. And I think the answer lies in what Sunil Lalai said at the beginning.
Correct, you are right.
The appendix.
Absolutely right.
The appendix, there should be an appendix which you should voluntarily prepare and keep it. That will straight away point it out. A second method could be, have a sticker. Put a sticker at that point, stick it or whatever, and say that on that, write in your own hand on that sticker that this has been amended on at the meeting dated so and so, and put that sticker on that. So whenever you refer to that meeting, you see that sticker and you will go to the next meeting where the amendment was made. Don't make the change in the minutes, but put a sticker there.
It's sticker is for your information and remembrance. Please don't take it as a correction. It's
not a correction. It's for your. That's why I'm saying a sticker.
Administrative convenience that you remember. That's all.
Yeah, it is only like a bookmark.
Bookmark.
But as Sunil Lalai said it very clearly in the beginning, you have an index so that you know what are the important events which has taken place.
The index will be the easiest thing.
That is the ideal situation. Ideal started in the beginning.
Ideal solution, which is mentioned at the beginning.
Correct.
Okay, this is written then. Mehta Mehta, any board annexure or report placed before the meeting like PPT, Forex, RPT, Forex, etc. shall be specifically mentioned each transaction or RPT, Forex as a part of minutes, or just noting of RPT statement and etc. noted in minutes. Basically, I think it says that when there is a lot of item and it is given as if I mention a list of related party transaction with detail, and whether it is, you have to mention each transaction in minutes, or you can just say that it is whatever list attached or list given is adopted. Here, I will leave it to panel rather than answering myself. Please. So the question is, it's not clear from here. Dhara, please clarify if I'm wrong. You can unmute and ask any question if you want. Mehta Mehta? Okay, I'll put that. What is the question is, in the board there is annexures and report, and it is placed before the meeting. Suppose PPT is there and foreign exchange transaction. Whether we have to specifically mention each transaction of related party transaction, Forex, foreign exchange as a part of minutes, or just noting of RPT statement, that related party statement or the PPT can be noted in minutes is enough.
Can I take that question? Dipti?
Panel, please.
Yeah. So,
sorry?
So Mr. Sunil, you can, then I'll add. Okay, please.
Yeah. So there is no common yardstick for the question that has been put across. So each transaction or each agenda item, like, a Forex report, for example, it can plainly be noted saying that yes, this particular Forex report was placed before. I'm just taking the examples what have been put up as a question over here. But as far as the related party transactions are concerned, each related party transaction recording is a must, because unlike a Forex report, that's only a report for the noting and consumption of the board members, saying that this is what unless there is a separate policy kind of. So the policy reference and various other details will come in, saying that whatever are the changes that have happened from the existing policy, what changes have happened subsequently to the policy, those will have to be recorded. But as far as related party is concerned, each transaction will have to be recorded, because that goes now with so much of amendment that's coming along in the LODR, specifically for listed companies, which is going to be effective from 1st April 22. Related party transactions is gaining a lot of significance and importance because of the, I would not say devious, but like, the intricacy and the maze of transactions which large conglomerates they are used to. It becomes I mean, it is bringing more on focus on the method in which the related party transactions are happening. So basically, noting in the minutes, it's not a simple answer where everything would fall in one bucket, but it will depend on each particular item which we are referring to. So I hope I have clarified to the best extent I am able to.
I think Dipti, the answer lies in 7.3.3 of the SS1, 7.3.3. Maybe I'll quickly read it out. It's 4 lines. Wherever the decision of the board is based on any unsigned documents, including reports or notes or presentations tabled or presented at the meeting, which were not part of the notes on agenda and are referred to in the minutes.
Agenda.
If they are not part of the agenda, shall be identified by initialing of such documents by the.
It is not part of agenda. Then.
Yeah, if it is not part of agenda, if it is part of agenda, then you don't need to initial it also. If it is not, if it is part of the.
Coming to that point only. Yeah, it is.
So answer is in 7.3.3. The answer is in.
Yeah, so it should be part of agenda, but what his question is that in minutes whether I should write it or not. So here it is on you to take a call, as Mr. Lalai mentioned, that there is no thumb rule, but there are minutes, as rightly someone I had told, that minutes are referred and resolution is referred. It's administrative convenience. You have to predict that if I write this in a resolution, it will help me for my practical implementation of resolution. Then you please add it. Don't say just statement. So it is your call. And if it is not generally question, if it is too many details, you need not. But if it is 2-3 transaction, but if it is that way a 4-5 transaction, but all are important, please add it. That will help you in future. And it's the call of CS, which practicality they have mentioned. And I was going to refer this secretarial standard. Very importantly, we mentioned, because what used to happen that people does the PPT and then it is not shared with the board member.
Correct.
Decision is taken based on that PPT. What was the logic is, many are asking the question why this is mentioned this way. So the board resolution is taken based on PPT, which is nowhere available. Because agenda is actually circulated, so somewhere that PPT is there, what is given to the board. If it is just presented, then only that presenter have that PPT. So tomorrow, if someone question the logic that why board decided in this way, and no one objected or anything, then board has precaution, that protection, that we have been given this presentation and this input and information. Based on that, this decision is taken, and we have taken proper care and precaution while taking this decision. This is the logic of this secretary. So this is very important.
I think the related party transactions also, when it is approved, or for that matter, the forex annexures, independent role, director's role is also crucial in that. So independent director also would like to see each and every item which are of prime importance, especially after 1st April 22. I think the whole scenario will change as per LODR for RPT transactions. So I think maybe there will not be what Mr. Sunil said, common yardstick, but it is always advisable to add and specifically get the approval and minutize the transactions very properly.
I think अभी आया उनका ही कॉल आ रहा है नहीं वो तो
Apart from this, Dipti,
Okay.
apart from what we just discussed, again, para 7.2.2.2, 7.2.2.2 says, apart from the resolution or the decision, minutes shall mention the brief background of all proposals and summarize the deliberations thereof. In case of major decisions, the rationale thereof shall also be mentioned. So duty is cast on us to do this. Para 7.2.2.2, 3 times 2. Apart from the resolution or the decision, minutes shall mention the brief background of all proposals and summarize the.
Hello.
Yeah. Yes. Hello.
Not able to hear Dipti.
Right.
Dipti, we can't hear you.
Now you can hear me?
Yes. Yes.
You can hear?
Yes, yes.
How? Next question is how can we get the meeting signed in case lockdown and meetings are held online? Yeah, actually we discussed this, but many are doing, certain people has checked the option of digital signature. Certain people are taking on a mail, the confirmation. So there is also the cases we have seen this way. Let's next take when a board meeting is conducted through video conferencing, can we pause the recording for discussing certain general or stress topics? How to address this situation practically? Panelists, please.
Can you repeat
Hello?
Can you repeat the question?
When a board meeting is conducted through video conferencing, can we pause the recording for discussing certain general or stress topics? How to address this situation practically? Panelists, is it clear or I will repeat again?
No. So basically, as what I correct me if my understanding is so what we are saying is whatever recording has happened through a video conference meeting, can that be shared for discussion on the draft minutes? Is that correct?
No,
or have I not
that.
got it correct?
No. What they are saying is, if the video conferencing is done, actually, the board wanted to discuss certain thing, general items. They don't want to get into that recording. Can they pause the recording? And
unethical way. Unethical way. I would not agree with that.
I also don't agree that
if it's a board meeting, everybody should discuss. It should get recorded. If they want to discuss something which is not a part of the board meeting agenda, they can off the recording. They can discuss otherwise.
Yeah, let me put it this way practically, as what I have experienced and what we have also been doing in a manner of speaking is saying that if there are any sensitive items, we go through the entire agenda in a manner in which it is supposed to be taken, and the sensitive item, they are discussed offline thereafter. So we have another maybe a set of meeting to discuss that specific item. So it doesn't hinder or hamper the flow of the meeting, as well as whatever the sanctity of the entire recording is maintained. So that's an ideal way of doing it. If there are other ways and means of doing it, I will be also happy to learn something.
I agree with Mr. Sunil that he has asked practically only, because so generally what the corporates do, that when they know there is a sensitivity in the item, they discuss in advance, inform the directors if they need any further information, briefing, all that is done in advance, and then they discuss it, as Mr. Sunil has rightly placed it.
Dipti, in some cases which I have seen, that directors doesn't want certain things to be recorded. Okay, so during the meeting only, they say, look, just post this, don't record this. Now stop recording, and we wanted to have something. And because maybe there are certain things which they do not want to be recorded, but it is happening in the many meetings where the directors want certain discussion is not to be recorded.
So here the CS role comes actually. Before that video meeting, all directors should be briefed in advance that please note that this meeting will be recorded and we cannot stop or pause in between. And if you brief that way, chairman also says in advance, then it doesn't happen. It is the duty of.
No.
Atul Bhai is trying to make a point that at one particular point in time there could be a heated argument or a heated discussion which directors or the chairman doesn't want to be on record. So how, I think if I'm not wrong, Atul Bhai may correct me if I'm wrong.
Yes, yes, certain thing which, they do not want to be recorded. Yeah.
We directors want many things, but law is very clear. If you will pause that, it will be questioned. I am telling you that. I know directors will tell, I don't record that. Physically, it will happen. But that's why I said that CS has to brief and train the directors. Even as rightly someone says that director don't say that roll call, they say, they get so irritated. Every time tum bolta hai and all that. But you have to say what to do, sir. At least we are saving your time and all that. But we have no choice.
No, so you are right, Dipti. So on just on that particular point, what just for the youngsters, it's basically on a practical side. A script is prepared and circulated at least a couple of days prior to the meeting, saying that this is how the sequence in which the entire flow of the meeting will go. So there is no ambiguity in the roll call sequencing as well as in the flow of agenda, saying that the chairman will take up this particular item and it will go in this particular manner. Now, what Atul is saying is it's right. There are situations, but if we are able to preempt and anticipate such kind of a situation, then those are well addressed ahead of the meeting, or that particular agenda item is saying that there is a sensitivity around it. So can we take it offline? And that's where the role of the chairman also comes, because he is the person who conducts the meeting. From the legal point of view, is the company secretary who guides the entire process. But the chairman plays a very pivot role as far as the conduct and the flow of meeting is concerned in a very orderly manner.
Because later on CS will be questioned about the sensitive, validity and all that thing. Because here again I am coming, this recording will be there for 1 year as per the requirement. But the minutes will be created. Now see, the minutes will be created, someone will check with the recording. Again, here the drafting challenge will come and it's required to be covering every point. Because again, I can say after drafting also, there can be directors who will challenge, no, I said this way, that way. So that's why in view of video conferencing, rather minutes drafting become really challenging. Because after 30 days, honestly, after 7 days, 30 days, generally people forget many things. But if it is video recording, again, it's a proof is created that what you have discussed has covered in the minutes or not. And minutes really challenge us. So it is also helpful that you can listen back and
Okay, Dipti. So now we have another question. So does it mean that one of the participants also raised the question on a chat book. So does it mean that the chairman? So see, all along we have read that chairman has a power to rectify those minutes or undesirable things. He can remove from the minutes also. So so ultimately is the final authority where he approves he signs the minutes. So tomorrow, any undesirable, see, I've seen in many board meetings where the director said, look, pause, don't record this. This, we wanted to discuss offline, and then you start recording again. So in that case, what I understand, Dipti is saying, look, he cannot stop this recording. But with due respect to Dipti, I have my different observation. The directors has a right, a certain thing which they do not want to record as a board. They will say, look, we are not recording. And see, tomorrow, even, those minutes been prepared, the chairman always have a right to include or exclude certain thing from the minutes. Yeah, this is what my observation.
Okay, fine. I said the validity will be questioned. Now, next question, because we have many questions left, please, we have to be very fast. 1 o'clock is there. Everyone is agree. If the time gap between 2 board meetings are not enough to follow the time frame of secretarial standard, then when the first minutes be sent. I think we answered this properly.
This question has been answered.
Already been answered.
This is answered.
Question from Mr. Ashish. In a board meeting conducted through CVAM means the video recording couldn't be captured, but the audio capture was clear throughout. The board took note of the same in the next meeting and approved the content of the audio clip and minutes thereof. Is it a proper course of action? All the resolution passed in the earlier meeting stand valid? If you don't mind, I'll answer. Yes, it will be valid because it is the board who decides and the chairman who decide what they want. And if entire board agree, this is the minutes and audio clip is there and it's sometime each happen. Better if you note down that also in minutes, that will help you in the next meeting. So that will help you when you approve these minutes. So that will also help you. Am I okay if a panel wants to add something to this?
Yeah, technical problem. Due to the technical problem, it has happened. Otherwise, it is available. If the board agrees, it's perfectly all right.
Yeah. The question from Mr. Viral, if a board meeting is conducted through video conference and later at the end of the meeting there occurs a situation that the recording has not been done or the video file has been corrupted, in such a situation, what recourse must be taken by company secretary? Does the meeting needs to be conducted again? How to satisfy the auditors or any other authorities which insist on the recording of the meeting within 1 year of the same meeting prior to AGM? Over to panel, please. So question is that a video is not recorded properly or it's not, this file is corrupted. Auditor is insisting, since it's during audit, how to attend this, how secretary, company secretary should deal with.
Yeah, it's a practical question where probably at this juncture, I have no, I have never experienced, so I may not have an answer to that, but going a little bit theoretical, is there is no need for a meeting to be conducted again, first of all. And maybe somewhere in record, it needs to go saying that there was an issue, a mail to all the board members saying that this is what has happened. And that can go on record, but how to satisfy the auditors? But because, see, as far as at least I have never come across a situation where the auditors ask for a recording. They go by saying that, yes, this is what the minutes have been recorded. At least in our secretarial audit, we have never come across a situation where the auditors ask for the recording, because it's on the face of saying that this is how the minutes have been recorded, signed by the chairman of that particular meeting, and the attendance and everything has been on record. So maybe I am a little flummoxed when it comes to this kind of question. Anybody else?
Yeah.
In this I'm of the view that secretary auditors should normally, as a secretary auditor also, we don't insist on recordings, what Sunil said rightly. And also it is a conscious decision. At the most, what we can do is we can ask for the company secretary while drafting the minutes, that is noting has to be done that there was a error on the part of the company to record the minutes. But the ultimate decision or the outcome of the minutes, you should read as a whole. And also the action taken in the next board meeting, next minutes has to be verified, so that the intention of the company and the intention of the management is very clear and it cannot be questioned. And chairman has signed the minutes. One more thing we can do is, if any member to whom we are board member, we have circulated the minutes, has put any comments on the same, has had any comments on the minutes which were circulated by the company secretary. So that also can be need arises when we verified. Otherwise, there is no requirement of conducting another board meeting, to the best of my this thing.
I will add one point that as regards secretarial auditor is and should ask, because that is one of the compliance of the Companies Act, that video recording is required and whether it is properly done or not, because that is there. As regards if it is not done properly, as we discussed earlier in earlier question, in that next meeting you cover it when you are approving the minutes, that there was a problem, the recording has not happened. However, we agree to the minutes and we agree there. If that is done, that is clear, because that is with the board consent. The ultimate intention is right minutes is recorded. So that's how the purpose. Yes, Mr. Bala, you wanted to add something.
Yeah, I have actually come across, not with the auditors, because in one of the companies there were about 4 board meetings were conducted on the audio conference or video conferencing, and one of the video conferencing the recording did not go well. Actually, somehow there's some technical fault, etc. The file corrupted, etc. The inspection took place within a year. When the inspection took place, it was the inspector who actually wanted to inspect and see. He wanted to see the recording. The company could successfully show all the 3 video recording. One of the recording they could not show that. Then he raised the issue on that. and they told there is some technical problem, etc. Another thing. In fact, really, as you rightly said, it was recorded in the next meeting. There was some problem in the video recording the last meeting. The IT department has been asked to rectify in future, etc. Luckily, the subsequent meeting has gone well. He has accepted that. And when the minutes are signed by the chairman, it is circulated 15 days and 30 days, all those criteria fulfilled. He said, okay, no problem. That's what he said actually. This is what is practically happened. Auditors I have not come across.
Okay, the next question is, if company old more than 50 years and old minutes of the company are traceable, then in such case,
Not traceable.
Not traceable actually. What steps to be taken by newly appointed CS?
Very tricky situation.
If
Very
company
tricky.
old, now it is nothing you can traceable in the sense take MCS search whatever, but 50 years nothing can be done. No answer.
So let me put it this way. Like, you know, when I joined my current organization, I took a sign off saying that these are the things which I have taken on record. Like, you know, they have come to my custody. Now, the same thing I'll do when I exit from a particular organization, saying that these are the papers which I'm handing over. Now, that's one way of looking at it. But in case, like, you know, if there is a fire or something that happens, and in such a situation, the records are lost or something, or that's another situation. But if incumbent who is joining an organization and he's unable to trace, or he's not able to, like, you know, say that, okay, these are all the records which statutorily are, and the permanent records that are to be maintained by an organization are not there. Somewhere it needs to be put on record, because not only the company secretary, the organization itself is liable in a manner of speaking for preservation of records. So somewhere then it needs to be documented by way of an affidavit, or it needs to come onto the records of the board meeting, saying that the minutes are not available. If there are practical sides to it, maybe I'll also be a little enlightened if somebody can share on this.
Yeah, at least better you write the reason if it is something, so that at least it shows that you rightly mentioned new CS has tried his best or her best, and I think you are right. Good suggestion. There is next question from Mr. Amit. How would one put in minutes of a meeting which is held online and where a particular director is interested in agenda item, as the law says he should not participate and remain present also? How one would ensure this? Panel, please.
Can you repeat the question, Dipti?
Yeah. How would one put in minutes of a meeting which is held online and where a particular director is interested in agenda item, as the law says he should not participate and remain present also? How would one ensure this? In the short, is telling that when it is physical meeting, interested director physically leave and we minutize. But in online, how we do this? Panel, please.
Yeah, so at least what we do in is, since the recording is also evident, like in terms of saying that, so the director walks out of the place from where he is sitting, and he generally abstains, like, no, that's how it's recorded, saying that he abstains from any discussion during the meeting. That's a practical way of doing it, and the video is bears an evidence of saying that, yes, this is how the meeting was conducted, where he was away from discussion on this particular agenda item where he was interested.
So actually, practically, I'm executive director, and how the director is actually doing is that they declare that I am interested in, I'm leaving this meeting. He switch off the video and even mute himself, and then he leave that, and then CS calls, then again person attends, and literally in a video person can be seen attending. This way at least you can do this.
Yeah,
And
just to add to what Dipti, what you are saying is that, say, for example, the chairman himself is interested, and there have been practical situations where the chairman himself is, because some relative of his is getting inducted on the board. So at that point in time, the Chairman also, one of the other board members occupies the chair, and the entire proceeding is well recorded. It's how minuted also subsequently, and the video recording, if somebody wants to see, that's how the flow of the entire sequence goes.
Right. Okay, next question. There are some of the directors who joins and leaves due to technical issue, personal work, and also doing video on and off, whether it will be treated as director attended throughout the meeting. Panel, please.
No,
Can
if
I
they are
repeat? Yeah, please.
if they are present for the particular item, if they are leaving, I think that will go in the record. He joined at this meeting, at this particular item, he left the meeting. Then subsequently at this particular item only he joined the meeting. That will get recorded in the minutes.
Now, again, he is talking about technical issue. If technical issue on the part of director, then it's okay. He immediately, as we mentioned, it's like, leaving the director for phone call. If for technical issue, that person is disconnected for some time and that person declared that I was disconnected, can I connect, what was the issue? Then you can take it because that's a technical issue.
Yeah, that is right. Absolutely, you're right.
But if it is due to the technical issue on the part of company, then better you connect and minutize that yes, there was a technical issue at the company level, at the place where the meeting is getting conducted. So then that will be also connected.
Correct.
But
You're
if
right.
director himself leaves, then as Mr. Mala says, then it should be. Okay.
Correct.
Again, repeatedly, I'm telling that it should be requested, the director should be briefed that how it will be happening, so they should know that.
I think the training part has to be there, or the flow. I think what Mr. Sunil said, the flow of meeting has already been narrated in advance.
It is required. We are
will solve most of these practical issues.
Yeah. Should the draft minutes be circulated?
1 minute, Dipti. Sunil, see, I've seen, many board meetings where the directors, they switch off their video, and I mean, so how do we consider this? He's there in the meeting, somewhere, but then he's switched off his video, So I don't know how it is to be handled. So can a chairman say, look, video has to be on. I should see everybody's face. Is it kind of a mandatory on the part of the directors who are attending a meeting that they should switch on their video?
So what happens is at the beginning of the roll call of the meeting, I mean, people, they say that we are able to see and hear everybody very clearly. So many times on practical side, what you rightly said, that there have been bandwidth issues, connectivity issues. And in such circumstances, like as a company secretary, what I do is I say that in case if there are any bandwidth issues or if there is any connectivity problem, then we'll pause for a moment and the meeting shall reassemble or get after the connectivity is re-established. So if there is a practical problem on the bandwidth issue, or if it's only an audio technical problem, I mean, I would say a video technical problem, then continuing with the meeting really doesn't matter, because finally the minutes are going to be a conclusive evidence, and the manner in which it would be recorded would be saying that the person had a video or connectivity problem and the video couldn't continue, but he was able to contribute, he was able to participate, and he was able to wherever necessary vote on particular agenda items. So to that extent, if we are able to establish that, that should be good enough.
Okay. The next question, should the draft minutes be circulated to the directors who had not attended the meeting? Yes, it is mentioned.
Yeah, it is mentioned. It is to be circulated. It is there very
It's
much.
all directors.
All the directors.
Does audit committee meeting and board meeting should be held on same day, keeping in mind the quarterly result approval?
Yeah, it can be done. You can do the audit committee meeting in the morning, board meeting in the afternoon.
In a general meeting, corrigendum would be issued and newspaper advertisement can be given. Okay, sorry. Someone has commented general meeting. Yeah, fine. Corrigendum and newspaper advertisement. Further, in case of change in venue, if any director is unable to attend due to change in menu, then I think hybrid mode of meeting must be provided. Okay, fine. Can a board of a private company directly appoint a person nominated by a venture capital investor, public company, as its nominee director without appointing as an additional director? If yes, then will such appointment is again required to be got approved at annual general meeting in terms of section 152 subsection 2, because it has a saving clause which states, save as otherwise expressly provided in this act, every director shall be appointed by the company in general meeting. How do we interpret this? Panel, please. Can I repeat the question if you want?
Yeah, please.
Can the board of a private company directly appoint a person nominated by a venture capital investor, which is a public company, as its nominee director without appointing as additional director? If yes, then will such appointment is again required to be got approved at annual general meeting as per section 152 subsection 2?
I think let's take it in parts.
Yeah.
First of all, to my mind, a person needs to come in as an additional director if I have got the question right. So without him being appointed as an additional director, I don't think that's the very first primary legal step that's to bring anybody on board. Right? And
yeah, please.
So the second question is what I understand is as far as the general meeting is concerned, right?
Yeah, again, that appointment should be approved in the general meeting
Yeah,
by
that
members.
that needs to be regularized at the general body meeting, because that's how the requirement of the law is.
I will just say, just add it. It's correctly mentioned by Sunil, Mr. Sunil. The only thing that a director is appointed as additional director, but he has full power as a director. Since it is appointed through board, it is called as an additional director and you file the form accordingly. So that's why it is a director, and it cannot be, there cannot be any exception. It will be added as additional director, as Mr. Sunil mentioned. Right? Any inputs, any additional points from other panelists?
No, this is perfectly right. He has to be appointed additional director, and he will be regularized only in the annual general meeting.
And only what is the conclusion is that from this, the general body has to confirm the appointment.
Right.
There is no option available for the board only to, even though the agreement to that extent must have been entered by the company with them.
Right.
The capitalist.
How do we record this in the board minutes, and should we record that it will be placed before AGM with regard to appointment of nominee director? Like other directors, subject to appointment and all that, in the general meeting, be appointed as a director. Same way, like other people, right?
Same way. Yeah.
Yeah. Then next question is, company has appointed individual as an additional director, which was subject to application and availability of dean, and resolution was passed. Company or PCS was requesting individual to provide documents. However, she was not providing after a period of 6 months of requesting. Company decided, as the individual didn't provide the documents, the company passed resolution for reskinement of resolution passed in earlier meeting, whether is it in a compliance of the Act, rules and secretary standard. Panel, please.
Director cannot be appointed unless he has a DIN number. Prima facie.
Yes.
So subject to appointment, the availability of DIN number and all, it is invalid actually.
I think it is a conditional appointment is not allowed.
Conditional appointment is not at all there. He needs to have the DIN number. In fact, when we appoint somebody, we write Mr. So-and-so having a DIN number so-and-so.
Yes.
That is what we record, we write it. So without the DIN number, no appointment is valid.
Yeah, it's like happening on some event only, they will be
Yeah.
appointed. That is not
Resolution
allowed.
itself, whatever they pass, it is invalid actually.
Mr. Suresh Menon, is it necessary for the company?
Hello, ma'am.
Yes.
Yeah, Chirag here. I have asked this question.
Yeah, please.
While making an application for DIN in DIR3, we need to make attachment as a resolution that this particular person has been appointed as a director, but
Right.
he has not been allotted the DIN at that time. So what would be the solution for the same?
Yeah, so the current requirement that for DIN availability, you require first the resolution from the company. Yeah, you are right. And that resolution is passed and they are not given. And that's why DIN cannot be applied. Then in that case situation, you have to resign and give the reason. That is the only option you left it, and give in that minutes everything, the reason why it is not there. And here you have written that as required by the provisions. We have mentioned that because that is a requirement to obtain the DIN. So you mentioned that he does not have DIN, and as the same is required for the DIN application, and DIN is required for appointment, we are passing this resolution for appointment. This way resolution is passed. And if you are not getting DIN, documents, the next time you are discarding that resolution, you mention entire facts and the reason, then it's correct because the company has performed the carry out the necessary.
Yes,
To
yes,
comply the
ma'am.
law, you have to pass earlier resolution, and to comply the law only, you are passing next resolution.
Right, ma'am. Right. Okay.
Panel, anything to be added?
No, nothing from my side.
Nothing from my side also.
Is it necessary for the company secretary also to sign attendance register?
Yes.
Of course, it is required. It is required.
Even sometimes the practicing company secretaries or invitees are there. I also.
We take everybody whosoever is presenting,
Yes.
including inviting.
Yes.
Refer secretary standard, even invitees has to sign.
Yeah.
In case of, see, it's very important. Again, I will add as a secretary standard board member. It shows that which all person came, and it's a proof that they made presentation. They were part of that discussion and they had provided inputs, and they are actually responsible for the same as well, because you are minutizing. Auditor was invited, he given comment. This all are is a proof. Okay. In case of listed company, it's mentioned in LODR that the quarterly compliance have to be placed before the board. Can we take the note of the quarterly compliance in next meeting after the compliance are made? Panel, please.
Yeah, so I'll take that question. So, like for example, if we are having 31st of December 21 as the quarter for which compliances have to be fulfilled, then maybe in the board meeting of January or February, those compliances have to be taken on record. Now, it's very unlikely that quarterly compliance would be after the board meeting. Say, for example, if we are talking about, or there is multiple board meetings, in that case, it can happen after the compliance has been fulfilled. And generally it forms part of a standard report where the corporate governance report, because the corporate governance report itself says that this has been placed before the board of directors. So I think that that's the next meeting only where the compliances have been made. The next meeting, the compliance report has to be placed before the board of directors.
Whichever the board meeting takes place following the quarter, it has to be taken. It has to be placed and taken on record.
Correct.
Okay. The next question is from Mr. Shiv Kumar. The shareholder passed a resolution at the AGM appointing an auditor to fill casual vacancy caused due to resignation with a tenure of his office to be from this AGM to the conclusion of the next AGM. Is such recording of this resolution in minutes appropriate? Shall I repeat?
So it is passed in the annual general meeting or EGM?
The shareholder passed a resolution at annual general meeting
Okay.
appointing an auditor to fill casual vacancy caused due to resignation with tenure to the office to be from this AGM to the conclusion of the next AGM. Is such recording of this resolution in minutes is appropriate?
I think somewhere maybe that's what my understanding. Somewhere the question has been, so the casual vacancy has happened and somebody else is filling in the seat of the auditor, right?
Right. So, but
Yeah,
in AGM we appoint auditor.
absolutely. Somewhere the question is misplaced. Maybe that's my what I hear.
My view, it is like always the general casual vacancies filled in the extraordinary meeting because
It can be in AGM.
No,
it can be in AGM, but then what happens if it is passed in annual general meeting? For what period? Because the resignation has come in between. So you must have the agenda items listed out for annual general meeting. So it happens that we mentioned in the director's report when we go for AGM that so-and-so auditor is appointed or so-and-so auditor is resigned. Now, can it be termed as casual vacancy if we are going in the annual general meeting? My question is that it cannot be casual vacancy. Casual vacancy is normally filled in an AGM. Annual general meeting, we normally appoint an auditor. Yeah.
Correct.
It cannot
casual vacancy is actually filled up by the board subject to the confirmation by the shareholders in the extraordinary general meeting. In the extraordinary general meeting, they confirm this casual vacancy of the appointed who holds the office only till the next AGM.
Right, but AGM is the agenda is predetermined. Everything is ordinary business, special. So it cannot be a casual vacancy.
It cannot be a casual vacancy.
I think so. Mr. Silkumar, if you are there, you can clarify. Otherwise, we'll go to next question.
Dipti, I got another board meeting at around 2 o'clock. So it's already 1:30.
Yeah, just two, three questions. I think it's all getting over.
I'm sorry, but I had to leave if you can attend quickly.
Yeah, in case one director is absent, then is it compulsory to circulate the recording to him or can he demand recording? Yeah, it is. We discussed everything to every director. Absolutely.
Yeah, all directors.
All directors.
While recording the roll call, it is necessary to record every director's speech in minutes, or can we put a general statement that a roll call was made and provisions related to roll call was properly complied? I think general statement is okay, right, panel?
Yeah. Correct.
Yes, correct.
When there is no whole time CS appointed or absent for a meeting and a PC is invited to conduct a board meeting, then is the appointment required to be taken in board meeting? And if it chairman invites any PCS to conduct a meeting, then can any director object to it and disallow of the PCS to conduct? Panel, please.
I have no past experience. Yeah, if somebody else can answer.
See, practically, company secretary in practice, full-time practice, is invited for certain specific matters and not for conducting the board meeting. If somebody, some director objects to it, I think it is a valid objection because per se, the practicing company secretary cannot conduct the board meeting.
He is actually an outsider for other businesses.
Yes, he is not on the muster roll of the company as a full-time company secretary, as well as he is only allowed and invited only for specific items.
Yeah, he is only providing the service to the company as a practicing company secretary. He is not actually part of the company, so he cannot be.
He cannot.
Okay, next question. This is the last question. In a private company, can company pass umbrella resolution in first board meeting of a financial year for RPT and accounting standard 18 mentioning board approves RPT transaction covered under section 188 and accounting standard 18, which will be at arm's length, or is it necessary to approve each and every transaction as and when it is arises? Panel, please.
I think the question is on the omnibus resolution, if I'm not wrong.
Correct.
It can be. Why not? It's
it
private limited or public. It doesn't prohibit from passing omnibus resolution.
Yeah, it can be done.
No, No, it is omnibus. I don't know. In a private company, can company pass umbrella resolution in first board meeting of a financial year RPT as accounting standard 18 mentioning that? If it is omnibus, there is a regulations and provisions which require that what is required to be done for omnibus. So for omnibus transaction, yes, there is a provision. If you comply, you can very well do it, right?
Yeah,
Yes,
you're
but what
right.
is it umbrella? I couldn't understand the meaning of umbrella.
I know. That's why I say
Maybe
omnibus
it could
is
be a
approval.
blanket permit kind of a thing, which is nothing but the routine in nature omnibus resolution, which is routine in nature, which is happening every year.
And it is mentioned by that every RPT has to be noted in every board meeting, even though it is
No, if it is a repetitive transaction which is happening and the omnibus approval can be
omnibus
taken.
approval can be given. Yeah.
Correct.
Yeah.
That's all the questions. I think we cannot take any more questions from public. As I mentioned that all the audience, we sorry because it's almost 1:35. But you can very well write to us and we'll come back. We'll pass on to our panel and get the answers and we'll send back to you. I thank Mr. Sanjay Dolakia and Mr. Sunil Lalai and our Mr. Bala and Shailesh and all the participants for the active participation. It was wonderful audience, wonderful discussion and very healthy discussion. Thanks a lot to everyone.
Thank you so much.
Thank you so much. Thank you.
Thank you so much.
Take care. Remain
Take
safe.
care. Stay safe.
Stay safe. Yeah.
That is the requirement of the day.
Thank you very much. Thanks.
Stay safe and be healthy.
Thank you.
Thank you.
Thank you. Bye-bye. Bye-bye.
Bye.